Good morning. Everybody's appearance on this, please.
Good morning, Your Honor. Nicholas Evers, P 88829 on behalf of the plaintiff.
Is Tyra Ford here?
Yes.
Oh, I'm sorry, ma'am. Your name?
Tyra Ford.
All right. Did you two go in a breakout room and speak this morning, Mr. Evers?
Yes, we did, Your Honor, and we did come to a settlement agreement by way of a conditional dismissal. If the court would like to hear the terms.
Sure, go ahead.
Thank you. We've come to an agreement that defendant shall pay plaintiff by and through their attorneys the sum of $5,525.13, with payments of $175 every month starting June 19th of 2026. If plaintiff fails to receive payment, both parties have stipulated to setting aside the conditional dismissal and entry of consent judgment for the amount of $5,600.13 less any payments made to date.
All right. So, ma'am, do you understand what he just said?
Yes, sir.
So this will be a conditional dismissal with agreed upon debt being 5,525.13 to be paid at the rate of $175 per month every month beginning on the 19th of June and the 19th of every month thereafter until paid in full. So long as you make that payment timely, the case will remain dismissed. And once you pay that amount in your increment of $175 payments, the case again will remain dismissed. If you miss a payment, then as I understand it, there's going to be, the total amount of the debt will be $5,613 less any payments made. Is that right, Mr. Evers?
Yes, Your Honor.
Do you understand and agree to those terms, ma'am?
Yes, sir.
And does Mr. Evers have your permission to sign your name to this proposed conditional dismissal?
Yes.
All right. Do you have any questions? You understand everything?
Yes, sir, I do.
Since you're unrepresented by an attorney, I do want you to understand if you don't understand something, you have 3 business days to come in here and fill out a motion to set aside the dismissal. You also have 10 days to appeal. Do you understand that?
Yes.
All right. Any other questions?
No, sir.
Anything else, Mr. Evers?
Just one thing for the record, Your Honor. I did have a chance to get Miss Ford a copy of the conditional dismissal, and I've received an e-signature on that, so I do not need a permission to sign.
Good enough. Thank you very much. Have a great day, you two. Thank you.
Thank you. I will submit it to the court.
Thank you. Kerning Advertising versus Maverick Fence, 2504871.
Your Honor, if I may, we did get something that the discovery is no longer needed. It was paid.
Okay, I'll
It
just
just
make a
came in.
note.
Thank you.
Judgment paid in full. Discovery hearing dismissed. Are they going to submit a satisfaction, a judgment on that then, Jennifer?
Yes, I will double check that they're sending one in.
If they don't, we will, okay? But let's make sure it's paid. So it'd be
Sure.
best if they do it since it's not coming through the court. Thank you. JP Morgan Chase versus Sherry A. Nadalny, aka Sherry Cernan, 2600079. Appearances, please.
Good morning, Your Honor. Brian Gruen, GROEN, P number 56673 on behalf of plaintiff JP Morgan Chase.
Good morning, Your Honor. Nicholas Rada, P 68328 on behalf of the defendant.
Good morning. Are you in Philadelphia, Mr. Reyna?
No, Judge, I'm actually in Grand Rapids.
I thought so, but they got the Philadelphia. I just wondered. I watched the PGA. It looked great.
Okay.
Anyway, okay. Did you guys resolve this or do we just need dates?
We just need dates, Your Honor. Defense working in conjunction with the debt settlement company, and the debt settlement company is located in Philadelphia. So maybe they saw the golf outing.
Yeah. Okay, you got 56673, Mr. Reyna. Let's see. What's your P number again, Mr. Reyna?
68328.
Okay. All right. So give me 1 second. All right, so today is June the, maybe 18th, June the 18th, July the 18th, I'll give you for discovery 8 cutoff. No ADR. Witness lists are due on June the 18th. Nobody demanded a jury, correct?
That's correct.
All right, I'm just going to put down 1/2 hour for trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. You don't have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. We'll give you a trial date night right now. Jennifer, I'm thinking like the end of August.
Judge, we can do the 24th,
At 10:30 in the morning? Is that
10:30.
correct?
Yes, please.
August 24th at 10:30 in the morning, okay?
Sounds good, Your Honor.
Thank you, Your
Here you
Honor.
go, CD. Thank you very much, gentlemen. Have a great day. Cavalry versus Cavalry SPV is S&E of Citibank versus Sabrina N. Paul. Sabrina Paul, 2600394.
Your Honor, I was on the phone with Mandarich Law Group. They're forwarding my message to a manager to find out why no one is here. I have no documents filed on it.
I'm gonna go ahead and dismiss the case. Unless we receive something. I mean, I don't know what to do. It's always these Chicago firms, you know that?
Yeah, they're very hard to get a hold of as well.
I'm gonna go ahead and dismiss it without prejudice. If they submit paperwork before I sign the order, I'll be happy to sign whatever it is that they give me, but they can't just not show up. LVNV versus Scott Whaling, 2600941.
Once again, Your Honor, Brian Gruen, GR OEN, P number 56673 on behalf of plaintiff LVNV Funding.
And good morning, Your Honor. Matthew Langston, P7983, appearing on behalf of the defendant, Scott Whaling.
Good morning, gentlemen. Is this going to be is there a resolution or you just want dates?
Same as the last matter, Your Honor. Just looking for dates. We're hoping this will resolve in the near future, but we're not there yet.
All right.
Exactly.
I'll do the same thing I did on the last one. No motions on the date of trial. Discovery cutoff is July the 18th of 26. No ADR. Nobody demanded a jury here again, true?
That's true.
Correct.
I'm going to set it down for, well, let me just finish. June 18th, witness lists are due. June the 18th. Discovery cutoff is July the 18th. And you don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. I'm sorry, Jennifer, it's Monday morning. What day did you give me? August what? At 10:30?
24th at 10.
August 24th at 10:30, right?
Correct.
Okay, so that's it. I'll send this out. Anything else either one of you guys need to bring up?
That should cover it this morning, Your Honor. Appreciate it.
Have a great day, guys. Thank you.
Thank you, Your Honor.
Thank you. Ayasadi, Joseph Abiasadi versus Christopher Andronic, 2600962. Do we have service? What's your name, sir?
Joseph Abiasadi.
Judge, there was alternate a service obtained on this case.
Money, they will refund it if it has been paid. Okay. You're welcome. Bye-bye.
Have you talked to this gentleman, sir?
I did, they're no longer interested in buying the property.
How much is due on the land contract right now?
55,000 with each lot, or 2 lots.
And did they pay 120 for both lots?
Yes.
So you think that you have $110,000 owed. Do you have an order, Jennifer?
Judge Linda's bringing it down right now. I had it
Perfect.
typed and I just forgot to get it off the printer.
That's okay. Can you just give me 1 second? Okay. Dick, why don't you have a seat, and as soon as she comes down with it, I'll recall you, okay? Crown Asset versus Karen M. Harvin, 2601040 OGC. Okay, appearances, gentlemen and ladies?
Good morning, Your Honor. Mimi Kalish, my P number is 52383 on behalf of Crown Asset.
Good morning. Ma'am, your name, please, Ms. Harvin?
Karen M. Harvin.
Did you two talk in a breakout room by chance, Ms. Kalish?
We did, Your Honor. Ms. Harbin is working with a debt settlement company, and she would like for us to communicate directly with them. I did propose a settlement, so I think that we've taken a positive first step.
How was your trip? Good. Okay. Just give me 1 second to write everything down here. So I'm just going to give you dates.
Very good.
52383, right?
Correct.
All right. So I'll do the same thing. Discovery is open until July the 18th. No jury, half hour. Are we doing the same date, Jennifer, for trial?
Yes, Judge, we can do this last one.
I'm sorry?
We'll do this one still the same date, August 24th at 10:30.
Right.
Very good.
Okay, so then witness lists are due June the 18th, half hour for trial. You don't need to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. And again, the bench trial date will be on August the 24th, and that will be at 10:30. You guys have a great day. Any questions, Ms. Harvin? So if they have something that you want, you can request that in writing from them, okay? Like
Okay.
if they have documents or papers, that's what we call discovery, the exchange of information, okay?
Okay, thank you.
Do you have any questions for me, ma'am?
No, I don't.
All right, best of luck to you. Thank you.
Thank you.
Very good. I have another matter at 9. I know it's before 9, so I'm just going to hang out until the court
Ms.
calls that
Kalish, if you
case.
could actually go into room 6, the defendant is here.
Okay.
Thank you. Just give me 1 second here.
Is her accent or leave? Or no?
Sir, when I call your case again, you're going to have to read this to me. I can't quite read all this writing on the forfeiture notice. So vacant graze number, whatever those numbers are, you're going to have that ready. Will you do that for me?
I can, if you give me the, whatever
Yeah, I don't have a problem with that. We'll give you that. Okay, John, hand that to him, please. And then I'll be right with you. Owners Management versus Kelly Wood, 2601718. Good morning, Mr. Lechner, your appearance.
Good morning, Your Honor. David Lechner, P number 67994 on behalf of Owners Management.
Ma'am, your name?
Kelly Woolworth.
All right, so you were going to speak to a lawyer. Did you do that?
I did not. I'm in the hospital. I've been in the hospital since the 5th. And I'm currently still in it. So I'm asking for the trial date and to be extended a little bit to give me time to get out of the hospital and get a lawyer.
Mr. Lechner?
Your Honor, I'm not going to object if she's been in the hospital for 13 days. So, I mean, I could object, but I don't think the court would look kindly on it. So,
Yeah, I know. So
yeah.
here's what I'm going to do. I'm going to go ahead and adjourn this 2 more weeks. And then if you want, I can give you guys a trial date a few weeks out.
Let's do that, Your Honor. Let's get a
Jennifer,
date
what do you
certain
have?
for a
2
trial
weeks
date.
from today is what?
June 1st, Your Honor.
We'll do it at 8:30, and then what's a trial date toward like the third week or fourth week of June?
Good morning.
We can do June 29th at 10:30.
June the 29th at 10:30. So June 1st at 8:30, ma'am. June 29th at 10:30. I'd suggest you get a lawyer here, okay? It's gonna
Okay,
be tough. It's gonna be tough for you, all right?
okay.
Thank you. Have a great day. Good
Thank
luck.
you, Your Honor.
Thank you,
Thanks,
Your Honor.
Mr. Lechner.
Yep.
People again, I'm sorry, Citibank versus Scott Kane, 2600566. And I do have a motion for summary on this one. Is Scott Kane here?
Your Honor, the parties are in the breakout room at the moment.
Okay, I'll pass that case and I'll go on to Jefferson Capital versus James Wood, 2600677.
Your Honor, I've not had anyone check in yet on that one.
I presume you haven't had anybody. Have you had anybody checking in Harbison and Jefferson Capital?
Yes, Miss Harbison's here. Her audio wasn't working. Miss Kalish was in a breakout room trying to speak with her. Miss Harbison, can you hear me?
I can now.
Okay.
Jefferson Capital versus Cassie Harbison, 2601006. Good morning, Ms. Kalish. Again, your name?
Good morning, Mimi Kalish. My P number is 52383 on behalf of Jefferson Capital.
Ma'am, your name?
Cassie Harbison.
Any resolution on this, or should I just set it?
You could just set dates, Your Honor, and I would encourage Ms. Harbison to shoot me an email at mimi@stillmanlaw.com. That's my first name, MIMI, at stillmanlaw.com if she wants to discuss settlement.
And in the meantime, I'm going to go ahead and give you the same dates as I did on the others.
Very good.
You can conduct discovery until until July the 18th. That's the exchange of information if they have something that you want. June the 18th will be witness list due. You have to file the names of all your witnesses and serve them on the other side by that date. And then the trial date will be August the 24th at 10:30. Okay, ma'am?
Okay.
Do you understand? Do you have any questions for me at all?
Nope. I think I got it.
Okay, you're all set. Thank you very much. Have a great day, you two. Thank you.
Thank you. You too, Jeff.
Here you go, JD. I'm not going to write anything on you. You want to come up here, Mr. Abiastani? Joseph Abiastani versus Christopher Andronic, 2600962 SP. Your name?
Joseph Abiastani.
So you have total damages of $110,000, correct?
That's correct.
And less than 10% of the purchase price has been paid. Is that true? I mean, less than 50%?
Yes.
Right? Okay, now give me that legal description if you would. I just can't read it because it's a photocopy. Jennifer, do you have a good copy of that? You can read me?
Vacant land.
Wait a minute. Slow down. What'd you say?
Vacant land.
Okay, vacant land. Go ahead.
Lot numbers 73-029.
Wait a minute. Slow down. Lot numbers. Go ahead.
Repeat. 73-02-0017-000.
Okay.
Second lot is 73-029-0018-000.
And what are the property addresses there?
There are no address, other than just vacant lots.
Okay. So I'm going to say an order of eviction may be entered. After the expiration of the order of eviction may be issued after 90 days if they don't pay the total amount, okay? And they just don't want the property anymore, huh?
Yeah, they just don't want it, and I just want to put it back up for sale. Just don't need it at my age.
Were you 55?
I'm 80 years old.
You don't look it. You don't look it at all. John and I look it. You don't. Sir, why don't you hand me back what we gave you so you could read that to me? And we're going to take this down for you. Jennifer, double check, make sure I checked everything. Will you please on that before
Yes,
we
Your
give
Honor.
it out and go from there? Thank you.
So,
Yes, you are. Go down and get a copy of your judgment. Thank you.
thank you.
LVNV versus Jennifer Nutman, 2601230. Jennifer,
They're in a breakout room at the moment.
Performance Equity Markets versus Margaret Osborne, 2601313.
Your Honor, I have plaintiff's counsel here, Mr. Schuler. The only problem is defendant's not here yet, and it's 9:07, so I don't know if we have to wait a few more
Yeah,
minutes.
we're going to wait another 8 minutes. And and then Scott Kane is still in,
Yes, Kane is in. Jennifer Nutman is back out now.
all right, LVNV versus Jennifer Nutman, file number 2601230. Okay, appearances, please.
Kara Bailey, P73071 on behalf of the plaintiff today.
Good morning, Ms. Bailey. Ms. Nutman, your
Good morning.
name?
Jennifer Nutman.
Are we just giving dates again?
We've actually resolved it, Your Honor.
Okay, go ahead.
We've decided to do a consent judgment. I'd like to put it on the record and get her permission to sign, and then I can e-file it today. So, we sued for $687.63. We had a court filing fee of $56.65, service costs of $40.13, and a statutory attorney fee of $75. The total balance of the judgment is going to be $859.51. Ms. Nutman's going to pay that in installments of $50 biweekly starting May 29th. And the judgment is going to accrue interest at the statutory rate. It doesn't preclude any it doesn't preclude any state of Michigan tax garnishments. I've discussed that with her, as well as I've discussed how to make the payments, and that if she fails to make the payments, that we will file an affidavit of non-compliance with the court, and the payment arrangement will be set aside without further.
Total's 859.51, correct?
859.41 is my calculation.
41. Do you agree that you owe that amount? Do you agree to those terms, Ms. Nutman?
I agree.
Do you understand this will be a consent judgment where a judgment will be entered against you by consent, both parties being in acquiescence? You would pay $50 bi-weekly beginning May the 29th. So long as you do that, there can be no garnishment of your wages. They could garnish your tax return still. They actually could garnish bank accounts still. But I want you to understand they're not going to garnish your wages so long as you pay that. Do you understand and agree to those terms?
I do.
And does she have your permission to sign your name to this proposed consent judgment?
Yes.
And do you understand that if you fail to make a payment as agreed upon, they can go ahead and begin garnishing wages and subpoenaing you for creditors examined and the like? Do you understand that?
I do. Yes.
Do you have any questions for me at all, ma'am?
No, Your Honor.
Okay, I wish you well. You can send that over, Ms. Bailey. Thank you very much.
Thank you, Your Honor. You guys have a good day.
You too. Performance equity, are we ready on that yet? Or has that not been, it's not been 15 minutes yet, right? How about
No, Your
Citibank
Honor.
versus Kane? Are we ready on that one?
They are still in the breakout room.
All right.
Performance Equities witness is running about 20 minutes late, Your Honor.
Well, Ms. Osborne isn't here, so I'm not going to call it for another couple of minutes anyways. I give them 15 minutes and we'll go from there. Do I have anything else ready, Jennifer? How about Jefferson Capital versus Wood.
Your Honor, I've not had anyone check in. I do have an attorney though in the breakout or waiting room that he's not responded as to what they're appearing on.
You should bring him in. Mr. Martinez, who are you with? Or Ms. Martinez, I'm sorry. Sorry about that. I can't hear you though. I cannot hear you. No, not a word.
Ms. Martinez, check and make sure your volume is up. So it does show on our end that you unmuted, but it's not.
Yeah, yep. Make sure your volume's turned on.
Can you hear me now?
I can. You are here on Jefferson Capital. What are you here on?
Yep, Jefferson Capital Systems LLC.
Versus Wood?
Yes.
All right, I'm going to give them a couple more minutes. I give everybody 15 minutes. This was scheduled for 9, so just give me a minute, okay?
Thank you, Judge.
No problem. What's your name, ma'am? Is she on the docket? Okay. Good to see somebody be here on time.
Your Honor, may I ask what was her name?
Teresa Roberts.
Okay, thank you. Mr. Groen is handling that one, so as soon as he logs back in.
Good. You know, I did that fast on the landlord contract. Would you just make sure I signed everything and checked all the boxes again?
Yes, Judge, I'm gonna look over it here in a minute.
All right. Yeah, it's Teresa Roberts. 9:30. Well, let me take the easy one here. All right, I'm going to call this Jefferson Capital versus James Wood, 2600677. Ma'am, Ms. Martinez, good morning again. Your name, please?
Good morning, Yadinise Martinez on behalf of Jefferson Capital Systems LLC.
Okay. Mr. Fanto's on this case?
I believe so, yes.
I don't remember lawyers or judges calling me when I was a lawyer, you guys. You know what I mean? I don't remember that. They never called me. Go call Mr. Fanto, will you please, Jennifer? Let me go on. Let me go on to understand. Performance Equity versus Margaret Osborne, 2601313. All right, counsel. Good morning. Your appearance.
Good morning, James Shirley for plaintiff.
Okay, so this is just motion for possession pending final judgment, right?
Correct. There's no request for a money judgment.
Well, but you're just asking for it temporarily, right? That's all your motion addressed, right?
In the
Can't
sense
give
that,
you a full judgment today.
correct. Yeah, just simply a motion for possession, an order for possession pending final judgment.
Yeah, I will do that. Did I adjourn this once or was he not served? She not served?
No, the original date was set just a couple of days after I got the summons and complaint back from the court. So this hearing is adjourned.
So you're going to go ahead and file, you're going to grant this, submit an order for possession.
Correct.
Pending final judgment, but then you're going to follow up on motion for summary, right?
Either a motion for summary or if there's no response, a default judgment.
He filed an answer though, right, or not?
No.
I think I'm going to prefer you to file your motion, okay? Submit an order for possession pending final judgment. Defendant failed to appear. Attorney to submit motion for summary disposition, okay?
All right, very good.
Have a great day. I did give him 15 minutes. It's 9:16 now.
All right, thank you, Judge.
Scheduled for 9. Have a great day.
Thank you.
How's things in Muskegon, Mr. Terrell?
Oh, they're wonderful, thank you.
Yeah?
We're coming into the summer
still
season.
practicing around there?
I'm sorry?
Mr. Nolan, Terry Nolan, is he still practicing?
Just saw him last week.
Nice. And what about his brother? He's just gladly retired, the judge.
Yeah, Mike's retired and their other sibling, Jeff, is a judge.
Okay. Jeez. Okay. Have a great day.
All right, thanks, Judge.
All right. I think I want you to get Kane out, Jennifer, unless they're making progress. If you want to just go in there and ask them, I can get off the bench
Sure.
for 5 minutes. Did you get hold of
Okay.
Mr. Fanto by chance?
We just left him a message, but I am noticing that when he put his answer into M file, he didn't add his appearance. So I'm not sure if a copy of the notice went to him because he didn't place himself on the case.
Counsel, why don't we adjourn the pretrial on this? Is that okay?
That works, Judge.
Let's set it out 3 weeks or so, Jen, or June 1st, whatever you want. If that's my next day.
Was that Mr. Fanto? Yep. Oh, Mr. Fanto's logging in right now.
Okay.
He just called. So let's
Good.
give him a second here.
Jefferson Capital versus James Wood, 2600677.
Give me 1 second, Judge. He
Sure.
was on the phone, so it's going to take him a second to get logged in.
They just couldn't make any shots.
He's joining now.
All right. Jefferson Capital Systems LLC versus James Wood, 2600677. All right, Mr. Fanto, good morning. Your appearance.
Morning, Your Honor. Jeffrey Fanto on behalf of Mr. Wood, and I apologize for my appearance, Judge. I didn't have this in my book, and I'm somewhere else. So.
Well, we might not have sent the notice, is what I was told accidentally. She said something about you not filing an appearance. I don't know. But anyway, no worries. Ms. Martinez, your name?
Berenice Martinez.
Am I just giving you guys dates today or am I?
Yes, please.
All right. So I will go ahead. Your P number 85282. And Mr. Fanto, you're a little bit of a dinosaur like me too, right?
I'm a lot of bit of a dinosaur.
34118. Boy, you must have got, what'd you get out? An 82?
Yes.
Jeez. Where's it gone, huh?
Yeah,
June the 18th, or July the 18th is discovery cutoff. All motions have to be filed and heard not later than 20 days before the trial date. Nobody demanded a jury. There will be no settlement conference. I'm putting down 1/2 hour. Witness list due June 18th. So again, witness list due June 18th, discovery cutoff July 18th. You don't have to file a trial brief. If you choose to file it, it has to be filed in exchange not later than 7 days before the trial date. I'm giving you August the 24th.
Your Honor, if I can, can we go to September 1st, please? We've got quite a few on the 24th right now.
That's all right. Nah, we can do this.
Okay, all right.
At 10:30. You guys, I usually let overrule me, but I'm gonna overrule you on this one. So we'll do August the 24th. Anything else, Mr. Fanto?
Nothing for Your Honor. Thank you.
Anything else, Ms. Martinez?
No, thank you, Your Honor.
You guys have a great day. Thank you very much. Nice
You as
to have
well,
you here,
Judge.
Ms. Martinez.
Thank
Bye.
City Bank versus Scott Kane, 2600566 GC.
Good morning, Your Honor. Tiffany Palmer on behalf of plaintiff P number 74809 for the record.
Good morning, Ms. Palmer and Mr. Kane. Your name, please.
Good morning. It's Scott Kane.
Did you guys resolve this, Ms. Palmer?
We did, yes, and we just want to put the settlement on the record.
Sure.
Great, Your Honor. So we have agreed to settle this in the total amount of $2,350.15, which is comprised of what we call principal damages of $2,108.93, a filing fee of $75, a service fee of $71.22, a motion fee of $20, and a statutory attorney fee of $75. We are not seeking post-judgment interest. We have also agreed to enter into a payment plan in which Mr. Kane has agreed to pay $200 a month starting on June 15th. And thereafter, the 15th of the month, until that total of $50.15 is paid in full. We have also discussed that we are prohibited from a periodic garnishment, but we are permitted to do a non-periodic garnishment, even with being on a payment plan. So we discussed that as well. And we discussed—
Wait a minute. So you guys are actually going to still garnish, you still reserve the right to garnish wages with this installment payment order? Is that what you're telling me?
No, I said we won't do a we won't do a periodic.
You reserve the right to garnish tax returns.
Yes.
Bank accounts.
Yes.
Okay.
Yes.
I got it. Thank you.
I'm sorry. I explained it to him, not using periodic and non-periodic. I shouldn't have said that. So yes, we, as I told you, Mr. Kane, we will not do a wage garnishment, but we may do a bank garnishment, although it's not our practice. As I indicated, that's not our practice to do that. And we do a state tax garnishment regardless, even if you're not in default.
Okay. So sir, do you understand everything she said?
Yes, I do.
Is this going to be in the form of a consent judgment, Ms. Palmer?
It is, yes. And we have obtained permission to sign his name to that order if it conforms when it's presented to you with what I put on the record.
So, sir, it's $2,350.15. And you are agreeing to pay this, according to Ms. Palmer, at the rate of $200 per month, beginning June the 15th and the 15th of every month thereafter until paid in full. They will not garnish wages, but they can garnish and do reserve the right to garnish bank accounts as well as tax returns, even if you're making the payments as agreed upon. She also tells me that you are giving her permission to sign your name to the proposed consent judgment. Is all of that true?
Yes, Your Honor.
All right. Do you have any questions for me at all?
No, I do not.
Okay. I wish you well. I'll wait for the judgment and you can send it over and we're all set. Have a great day, you two. Thank you.
Thank you. You too.
Bye now.
Thank you, Mr. Kane. Thank you, Your Honor.
Thank you. Bye.
Bye-bye.
Jennifer, did I call this? Oh, okay. Do I have anything else ready down there?
Your Honor, I'm waiting for plaintiff's attorneys on the 930s. I have all the defendants here.
Do you have the 930s, John?
It's 3 pretrials.
Okay. Thank you. It's supposed to rain later, huh?
What was it?
My wife said it's supposed to thunderstorm or something, or storms after 6.
What?
I'll wait here and see if a lawyer pops in, Jennifer. If not, I'm gonna get off the bench here.
Okay, Your Honor.
So nobody from Mr. Whitty's office, Ms. Taylor's office, Mr. Price's office.
No, and I know Mr. Groen will be in for Mr. Price. He had let me know he was covering that one this morning when he was in. So he should be logging back in.
Okay.
And I don't know if you're going to want them to talk, being they're all pre-trials. Well, I know Miss.
Why don't I'll get off and let them talk, okay?
Okay. I was going to say, we got plenty for you to sign.
I suspected that. Okay, all right. Ma'am, you can stay seated and, if you see the lawyer pop, who's her lawyer? Well,
Mr. Groen is on that case.
just know that Miss Roberts is here and she could talk to the lawyer in the breakout room.
Okay. Yeah, we can get her on a tablet if needed.
Okay.
Sorry.
On Saturday, I believe.
Motion to stay what?
Proceedings
Why?
to try and settle.
No, I can't do that, ma'am. You guys can certainly talk and continue doing what you're doing, but I'm going to give you some dates here, okay?
And Your Honor, that motion was filed at 8 p.m. on Friday, so we have not processed it yet.
No, I get it. I
Okay.
get it.
I made a proposal that they rejected.
Okay.
With a stipulated order, conditional dismissal that they rejected.
Well, how much is the total claim for, Ms. Gertzberg?
Sorry, if you could just repeat that, sir. I didn't actually.
How much is the total claim for?
Minus court costs, it's $7,607.46.
And what was your offer, ma'am?
60%, 4,000.
Well, yeah, I can't force him to do that. I can't force him to do anything, but here's what I will do. I'm going to give you discovery until July 18th. Witness lists are due on June the 18th. There is going to be nobody demanded a jury trial.
Yes, they did. I did, Your Honor.
You demanded a jury trial? You're going to be able to try a jury trial on your own, ma'am?
43 years in the legal system.
Well, I know. What did you do?
The paralegal.
I know, but you never went to court, right? Look, I don't care.
I worked for Figer. I went to court.
Well, that's fine. All right, here's what I'm doing. Give me a jury trial date, Jennifer. So I'm going to just repeat so far. June 18th will be the witness list due date. July 18th will be the discovery cutoff date. You're going to have to submit. We're going to have a settlement conference date a month before the jury trial date, Jennifer. I'm going to put down 1/2 day for trial. And you give me a date in early September for the trial and second or third week of August for the settlement conference.
I'm sorry, Judge, you wanted the jury when?
Early second week of September, something like that.
Okay. We can do September 11th.
Okay. At 8:30. At 8:30 in the morning will be the trial date.
And then
the
we have to go.
Date, just back up. We could do that on August 24th, frankly. Let's do it on August 24th.
Okay.
And we'll do it at 9:30 in the morning.
9:30. Okay.
And then you don't have to submit voir dire questions, but you do have to submit proposed jury instructions. And those are due not later than 14 days prior to the trial, not later than 14 days. So each of you have to submit proposed jury instructions. I will send this out. This was a credit card debt, right?
Yes.
Do you have a defense to this, ma'am?
Working on it.
What that means. Do you have one that's come to your head? I mean, do you have, I'm just telling, listen, you know, I'm going to keep an open mind here, obviously, but credit card debts, they're usually pretty straightforward, but that's neither here nor there. I'll set these dates up. She can file her motion for summary disposition. You guys can conduct discovery.
When
and
is
we'll
the MST date?
What's that?
When
All
is
motions for summary have to be filed and heard not later than 20 days before the trial date. So since the trial date is going to be on, you know what, Jennifer, let's, let me see here. Yeah, that'll give you plenty of time. Discovery cutoff's July 18th, so you just have to have it filed and heard by, what would that be, August the 28th?
Your Honor, I was gonna say I could give July 27th at 9 if they want the SD date now. Okay.
July,
27th at 9. It'll be after discovery cutoff and before our settlement conference.
so I'll just write that down, motion. I might have to work with you on this one, okay? You said July what?
27th,
At what time?
9 a.m.
At 9 a.m., okay? All right, and if you have a motion, ma'am, you can file it for summary before, so it's heard that day, or if you have another motion in the meantime, you can file that, okay? Thank you very much. Good luck. You can set the motion to stay proceedings. I'm just telling you, Ms. Kitchen, I'm not going to be able to grant that, okay?
I understand.
I just we don't stay proceedings pending negotiations. So this will give you plenty of time. So if you still want me to have it heard, that's fine. I'll be glad to set that. Jennifer, why don't you just set it unless Ms. Kitchen wants to withdraw it, okay?
Okay, Your Honor.
Thank you very much. I'm going to go on to these couple criminal cases real quick. Let's take, who do you have there, Miss Lieutenant?
I have Sean Johnson.
Yeah, Sean Patrick Johnson, 260-648-429. Also, I have 25R 514-397 A, B, and C. Okay, Mr. Granada, your appearance.
Morning, Your Honor. Peter Granada, P78413, and my DC counsel for Mr. Johnson.
Sir, your name? Mr. Johnson, I need your name.
Sorry, Sean Johnson.
Lieutenant, your name?
Detective Lieutenant Steve Merker, Rockwood Police.
All right, for purposes of arraignment, does he stand mute, wait formal reading?
Yes, Your Honor.
On the suspend, what about on these failures to pay?
Your Honor, I've had a chance to talk to Mr. Johnson, and they're on the last time he was supposed to be in front of this court on April 16th. His wife went into labor that day, and he failed to contact the court to let them know that he was indisposed. He was at the hospital with his wife. I believe that she delivered the very next day, but with all that was going on, he failed to get back in touch with the court to try to reschedule that date. That's the reason for his failure to appear. The reason that his license is suspended is the citations that were written out of Gibraltar, the stop sign, no insurance, and mobile device. As soon as those tickets are paid, he should be able to go back in the Secretary of State and get his license back. But unfortunately, Mr. Johnson has got under financial hardship right now because his wife has been off of work because of her maternity leave and without pay. And they're already in a situation where they're on EDT. I think they have a bridge card as well as some cash assistance from the state. And we would ask the court to consider, even though he had a failure to appear, if you look at his criminal history, there hasn't been anything since 2014. And again, the only reason his license is suspended was unpaid tickets. We would ask the court to set a personal bond.
Man, I don't think I'm going to do that for you, Mr. Johnson. Why didn't you show up here? I get the fact that your wife went into labor. Did you have the baby?
Yes.
Did she have?
She ended up having him early.
Baby healthy?
He was premature and had to stay at the hospital for 2 weeks, but he's home now and doing good.
You got these tickets back in November of 25. You didn't show up for the department rep hearing. You didn't show up for the show cause. You didn't bother contacting the court on that day or subsequent thereto. Now you're in here again. You got a problem with me. Where do you work at?
I usually just do side jobs with my uncle.
Why aren't you working?
After I got the pulled over with the no insurance and everything, that was my mom's car, and she had just passed away right before I got pulled over, so I wasn't even aware that there was no insurance or anything. And it's like 3 weeks later, the car broke down and has since been repossessed, so I didn't have a vehicle.
You live on John R?
What's that? Sorry?
You live on John R Street?
John R Street, yes.
Your Honor, if personal bond is not available, we would ask the court to set as low a cash bond as possible because setting a higher bond means, in effect, based on his financial hardship, there's no bond.
Gotta grow up, son. 2,010% on the suspend. And I'll give you a personal bond on the Rockwood cases. We're gonna set those for May the 21st. All of these will be heard on May the 21st at 10 a.m., okay? May 21st, 10 a.m.
Thank you, Judge.
And you gotta post $200. Don't make this worse than it is. If you do this again, I'm gonna call Trent and have him come get you. You got it?
I understand. Thank you.
All these are gonna be on May the 21 at 10. Don't make things worse for yourself, okay? If he wants a court-appointed lawyer, Lieutenant, will you have him fill out a petition for one going forward, please? May 21.
Yeah, we already did.
Thank you
You already
very
told him I'm
much.
sending the court.
Thanks a lot.
Thank you, Judge.
Thanks a lot, Mr. Granada. All right. Do I have other ones with Trenton? I see.
There was a Trenton case in there.
Well, I know they're all with Johnson.
Yeah, fellow same guy.
Okay, Detective Shapaniak, I guess you're all set, right? Or do you have something else for me?
No, Your Honor, I was just checking in, just make sure.
Okay, thanks a lot. Have a good day. Midland Credit versus Lee Bondernock, 2601321. Who's here for the plaintiff? This is Midland Credit versus Lee Bondernock.
Your Honor, I've not had counsel check in. I have called and left a message with the firm.
Jeez. Time is this scheduled? 9:30? LBNV Funding LLC versus Teresa Roberts, 2601897.
Good morning. Once again, Your Honor, Brian Gruen, GR OEN, P number 56673 on behalf of plaintiff LVNV Funding.
You haven't talked to the defendant, have you?
There was, I think, some type of glitch with the equipment down at the courthouse, so they could not get us talking at all.
Your name, ma'am?
Lee Bondernock.
No, not yet. I'm on another case. I'm sorry. All right. So, ma'am, I'm going to give you dates. You have to file a witness list identifying the names of all your witnesses by June the 18th. Okay. There's discovery cutoff. That's the exchange of information. I'm going to set that in this case for July the 18th. Then the trial date will be August the 24th of 26 at 10:30 in the morning. I'm putting down half an hour for trial, no settlement conference. You don't have to file a trial brief. If you choose to file it, you have to file and exchange it not later than 7 days before the trial date. So if they have something you want, you can ask for it. They have to give it to you. If you acknowledge that you owe the debt, you could go in this is only over $647.95. You agree that you owe that debt, ma'am?
I agree, I owe it, but I don't agree on the amount.
How much do you think you owe?
My credit limit was $300, and I did previously try to make arrangements with them because.
Yeah, but what happens is you start to get late fees.
Yes, and I had.
How much do you think you owe?
Maybe like 3 something, but I don't think.
Maybe like, okay, so one thing great about math, again, there's only one right answer, right? Nobody ever passed the test saying about 300 and something. You go figure out what you owe. I'm gonna give you these dates. Doesn't make any sense to go on if you don't have a viable defense. So figure out what you owe, go back and look at what they charged you, figure out if those charges are accurate. I'll give you these dates. We'll set it for a trial. If you want to talk to Mr. Groen in the interim, you can feel free to do that and we'll go from there, okay?
I did want to speak to him previously to try to make some kind of settlement arrangements because I am working only part-time and I do have.
If you agree that you owe the amount and you guys resolve it that, you can also agree on an installment payment plan. And if you can't agree on the amount that you should be paying, that you can afford to pay, then you can file a motion and I'll decide. Okay? So, I mean, I would get on the phone with Mr. Groen here in the next few days, see if he can resolve it. And you guys can submit a consent judgment or a conditional dismissal, whatever you agree upon, and we can go from there. Okay?
Yes.
They're usually pretty good about, agreeing to payment plans. And if they don't, and you think you can't afford what they're asking you to pay per week or per month or bi-weekly, then you file a motion and I'll decide. Okay? All right. Any questions? We'll send the pretrial order out here. You get it the next week. Okay? Good luck. So there it is.
Thank you, Your Honor.
Thanks, Mr. Groen. Midland Credit versus Lee Bondernock. Is the lawyer not here still?
No, Your Honor, we're trying to make a second phone call, but we're not getting any answer at the office.
Lake Trust Credit versus John Andrew Jancy and Barbara Joe Jancy, 2600737.
Hello, good morning.
Good morning.
Good morning, Your Honor. Andrew Galster, P 52839 on behalf of Lake Trust Credit Union.
Right. And where is Mr. Jancy?
Can you hear me, sir? I'm here with my wife, Barb.
Oh, I'm sorry. I can see you there now. I'm sorry.
Okay,
My apologies. Mr. Galster, you are the third?
Yes.
Okay. And let's see, P number 52839. Okay. Tell me your name again, Mr. Jancy.
John Andrew Jancy.
Ma'am, your name?
Barbara Joe Jancy.
All right, so he thinks that you owe his client $22,607, $667.16, 22667.16. Do you owe that amount?
I don't think so, sir.
How much do you owe?
That I don't know until I get discovery completed. My fundamental question on what I owe concerns reasonableness on the auction of the motorcycle and the timing and the process and procedures that they followed to dispose of that asset.
Okay, here's what I'm going to do. Same thing. Witness lists are due by June the 18th. I'm going to put down 1/2 hour for trial. That will occur on August the 24th at 10:30. You have until July the 18th to conduct discovery. That is the exchange of information. So you have to file your witnesses by June 18th. You have until July 18th to conduct discovery. You do not have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. Nobody demanded a jury trial here, right?
No. Correct, Your Honor.
Okay, so I'm going to give you these dates. You can conduct your discovery. We'll go from there, okay?
Okay.
Is there anything else
Yes, sir. Will I get the dates like in an email or a letter or whatever?
Yeah, I'm gonna sign a pretrial order. We got quite a few of these today and we're busy, so, but you should have it without a doubt in the next week.
Okay. Thank you very much,
Okay,
sir.
and it'll have all those dates, and make sure you read it carefully. All motions for summary disposition have to be filed and heard not later than 20 days before the trial date. Okay?
Okay, sir. Thank you.
Have a great day. Thank you
Okay.
very much,
Your
Good
Honor.
luck, folks.
Bye-bye. Thank you.
Thanks. Here you go, Watson. I got Nichols and Ebert versus Samantha Duclo, 2601530. Where do I have Nichols and Ebert or Samantha Duclo?
Judge, they are still in a breakout room. You want me to bring them in?
No. Creekside versus Alice Bester, 2601611.
Judge, they're still in a breakout room as well.
Meadowlands and Lore. Meadowlands versus Noah Lore and Heather Lore, 2601738.
Good morning, Your Honor. Attorney Bears of Salem on behalf of plaintiff.
Good morning. Your name is Lore?
Heather Lore.
So I don't know if it's your husband or what have you. Is Noah your husband?
No, he's my son. He's working. He has a really hard time getting out of work on his schedule.
All right. He was not here last time, and I did say he had to be here. What do you want to do? What are you guys doing on this one? What are you doing on this, Ms. Salem?
Your Honor, we did come to an agreement for a consent judgment. I can put the numbers on the record.
Okay, and it would have to be a default versus Noah, okay?
Correct.
Go ahead.
Rent is $3,129.93. Late fees are $80, and that's 2 months of late fees at $40 each. Court costs are $238.43 for a grand total of $3,448.36 to be paid on or before May 28th.
All right, ma'am, do you understand and agree to those terms?
Yes, sir.
Do you agree that you owe $3,408.36?
Yes, sir.
You understand you have to pay up that amount by May 28th. If you don't, you have to vacate. If you don't do either one of those, then you're going to be evicted. You understand that?
Yes, sir.
You have 3 business days, since you're unrepresented by a lawyer, to come in here and fill out a motion to set aside the judgment. You also had 10 days to appeal this. Do you understand that?
Yes, sir.
All right. Do you have any questions for me at all?
I do not.
Does Ms. Salem have your permission to sign your name to this proposed consent judgment?
Yes, sir.
All right. So you send that over. And again, it's a default versus Noah, consent versus Heather. And I will sign that. I wish you well, ma'am. Do you have any other questions?
No, Your Honor.
I'm not sure if it was just my phone breaking up, but the grand total was $3,448.36. I think I heard 3408, but it's 3448.
That's fine. You agree to that, Ms. Lore?
Yes, Your Honor.
Okay, so you're all set. You can send that over. Thank you very much. Good luck to you guys. Good luck, Ms. Lore.
Thank you.
Thank you, Your Honor. All right, have a good one.
Creekside and Bester are still in there, and Duclo and Nichols, right? How about LVNV versus Schmidtke? Carly
Your Honor,
Schmid.
Ms. Schmidtke is in the courtroom. This is a transfer case. I've not
Yeah, I
had
see
anyone
that.
check in yet on
Should be
Zoom.
Mr. Groen. Is Mr. Groen still out there? Or maybe he didn't
He
know
is
this.
not, but he may not be who handles matters for the 27th District Court.
Your
Would
Honor,
you-
I'm actually here, Lisa Schneider, covering for Stanger.
Okay,
who's
let
the
me call
attorney.
that case. LVNV Funding LLC versus Carly Schmidtke. This is file number 2600660. I'm sitting as a 27th District Judge on this. Ma'am, your name?
My name is Carly Schmidtke.
All right, Ms. Schneider, your name again?
Lisa Schneider on behalf of the plaintiff.
All right, so it looks like Judge DeSanto disqualified, I believe, and this was reassigned here. And this is the date scheduled for a pretrial. Did you two talk, Ms. Schneider, you and Ms. Schmidtke?
No, we did not.
Do you agree that you owe this amount that they claim, ma'am?
I do agree. However, I was not properly served.
Why weren't you properly served?
Nobody came to my door and handed me a summons and complaints.
How did you find out about this?
Well, it's a unique circumstance. I actually work for Judge DeSanto. I am a civil clerk. Therefore, I found out about the case by looking at the queue on my file.
All right. Well, I mean, I guess you could file a motion to quash the summons and complaint. But you appeared here, you're really submitting to the jurisdiction of the court. There's not really a reason to drag this on. If you know what I'm saying? And if you want to go into a breakout room and talk with Ms. Schneider, do we have proof of service here, Jennifer? I don't have.
Your Honor, all I received was the notification of the removal. Yeah, the DQ. And I emailed over to 27th and asked if we needed a pretrial, and I was told yes. So that's why one was fed. We were never, I didn't receive any answer, proof of service from the 27th. So I just posed the question to them what we needed to do once it was disqualified.
Do you want to talk to Ms. Schneider, see if you can work something out?
I would like to, yes.
Can we get that computer going, John? Was there an issue?
I don't know what the issue was with the, I'll talk to Will and see what the issue.
Okay, let's have you, Ms. Schneider, why don't you try to talk to her? We'll take her to a computer and put you guys in a breakout room, okay?
Sounds
All
good.
right, so you can go to my court officer. Thank you. Now, do I have Midland Credit versus Lee Bond or not? This is 2601321.
Your Honor, we've made 2 phone calls, left 2 messages, and still have no one from plaintiff's office that has checked in.
Ms. Bondernock, you can unmute and tell me your name. You have to unmute, bottom left-hand corner of your screen.
Apologies, Your Honor. Lee
That's
Bondernock.
Okay, listen, here's the problem. They didn't show up. Now, I can dismiss it, but they're going to file a motion to reinstate the case. I don't know why they're not here. We called them twice. They should be here. It's very surprising to me that this happens, but the lawyers didn't show up. I can either adjourn this 2 or 3 weeks, or if you want, I'll dismiss it. I'll dismiss it without prejudice, and they'll be able to file a motion to set aside the dismissal, which I'll likely grant, barring them intentionally not showing up.
Your Honor, I talked to Mr. Henry Watts on May 5th, and we came to an agreement. I submitted a letter to the court in lieu of the notice to appear, and we've agreed on a payment schedule, and my first payment was actually made on Friday.
I hate that. Why didn't they send us anything? They didn't send us anything, Jen?
No, Your Honor, I checked the box multiple times today.
I'm going to reschedule this for June the 1st. If they don't show up, I'm going to dismiss the case. You can convey that to them. 8:30 in the morning, June the 1st, okay? So
Okay,
that's
thank
what I'm
you.
doing. They got to at least tell us. Just common courtesy in the profession, you know what I mean? I don't need court
Right.
to spend time calling lawyers and begging them to show up, but it happens more than I can imagine, more than I ever dreamed of. But at any rate, that's what I'm going to do. If they don't show up June 1, I will dismiss the case. Thank you. Creekside versus Alice Bester, file number 2601611.
Good morning, Your Honor. Jennifer Werbling appearing on behalf of the plaintiff in this matter.
Where is Alice Bester? There you are. Good morning, ma'am. Your name?
Good morning. My name is Alice Bester.
So we adjourned this a couple times, Ms. Werbling. We had it, we were in here on April the 20th, and then it got adjourned to May the 4th, and then we adjourned it again. I don't know if she was applying for funding. Did you apply for funding, Ms. Bester?
Yes, I did apply for funding, but everything was denied because I didn't have anything with the current amount that's due. But I talked to the lawyer and she said that with this judgment, I should be able to get funding.
Oh my
Well,
God.
they're not supposed to need a judgment. They don't need a judgment. The summons and complaint are sufficient. I don't know why we get that word sent back to us because it's just not accurate. Ms. Verbling, what do you want to do?
Well, Alice, I read what was owed and she indicated she was in agreement to either pay by money order, by 5/20, by on or before 5/28, or she was going to leave.
All right. You want to give me the breakdown?
Sure. The rent to retain was $4,889.73, and then court costs were $191.07, and the total is $5,080.80.
All right. So did you two talk about a consent judgment or a conditional dismissal? Which was it?
We talked about a consent judgment.
So, ma'am, she tells me that you agree that you owe $5,080.88. Is that true?
That's true.
Do you understand you would have to pay this on or before the 28th of May or vacate? If you do neither one of those things, then you're going to be evicted. They're going to submit an application for a writ. I'm going to sign it. You'd be evicted. Do you understand that?
Yes, I do.
You agree to all those terms?
Yes, I do.
Does she have your permission to sign your name to the proposed consent judgment?
Yes.
Since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. You have 10 days to appeal. Do you understand that?
Yes.
You fully understand everything?
Yes.
Any questions at all?
No questions.
Okay, Ms. Werbling, you can submit your judgment. Have a great day, you two.
Thank you,
very
Your Honor.
much.
Have a good day.
Do I have Nichols and Ebert, PC versus Samantha Duclos?
Yes, Your Honor.
Good morning, Mr. Lampkin. Your appearance?
Brent Lampkin on behalf of Nichols and Ebert, PC.
Ma'am, your name?
Samantha Duclos.
Any resolution?
Not yet. I know we have discussed the potential of settlement, but I left it with Ms. Duclos, and I have not heard back from her since we last spoke about settlement. So
Ma'am?
No, Your Honor, we haven't. He offered.
I don't need to know.
Oh, okay. Sorry.
I don't really need to know what he offered. Are you close to accepting it or not?
I am not able to accept the conditions.
And because you don't owe the debt or because you can't afford to pay at the rate he wants you to?
The latter, yes, Your Honor.
So here's what could happen today. If you agree, and I don't care what you do. I can give you dates, we can set it for trial. But if you agree that you owe the debt, it doesn't make any sense to fight it. And there's 2 prongs of every lawsuit, essentially. 1 is whether or not the debt is owed, and 2 is ability to pay. So if you guys wanted to agree to a consent judgment on the total amount or whatever it is, including costs and attorney fees, I'll be happy to swear you to an oath today, and I'll determine how much you can afford to pay on a weekly, bi-weekly, or monthly basis. Does that make sense to you?
Yes, it does, Your Honor.
Do you want to do that, or you want to set it for trial?
My concern was the amount as well. I did question it with them, and that was where everything kind of started to happen. I questioned the amount with Mr. Eberth, who was my attorney at the time. And he said he would look everything over and get back to me. And that's kind of where we left that. So I didn't get a settlement offer from him.
Can I interject here? I want to bring something up with you. Mr. Eberth is our court management counsel.
Okay.
They pass budgets. He's the treasurer of Brownstown. I know Mr. Eberth. I want to disclose that it's not going to make one difference to me as to whether or not it's Mike Eberth or whoever else in the world. I'm not going to treat him worse. I'm not going to treat him better. I'm not going to treat you worse. I'm not going to treat you better, but I want to disclose that. And if you have any questions regarding my relationship with him, you can ask me questions.
Okay.
Do you want to ask me any questions?
No, I have absolutely no issues with Mr. Eberth. He was a great attorney.
No, I just want to make sure that you don't have a problem with me handling the case, ma'am.
No, if there's no biases, I have no issues.
Okay. Okay, so tell me how far you guys are apart. Maybe I can help you. If I can't, I shouldn't really be getting involved in settlement negotiations a lot on a bench trial. To be honest with you, I don't do it. But if you guys are real close, maybe I can help. If not, fine. I'll just set it for trial. Do you agree that he did the work that he's charged you for?
I was not sure of that aspect of it. I was concerned that in 2 months, my balance had accumulated almost $7,000. So I was just like caught off guard with that. And so when I
Divorce
reached
is finalized now, right, ma'am?
yes,
Were there
everything's done.
children?
Yes, there were children.
Okay. But I mean, do you have any questions about whether or not he did the work?
We're happy to try the case, Your Honor, if she wants to do that. And we'll stand by our work. Mr. Eberth will testify. There's also was communication with her a year ago about resolving the balance, and she was supposed to get back to him. He has text messages that he supplied to me and I gave to her to prove that he was in communication with her. She probably just can't afford to pay it. So now she's questioning the charges, and I understand that position, but we're happy to just present that to the court if she just.
So, ma'am, it really is very simple. You can either tell me, Judge, I just want to go to trial. I want them to prove what the fees were, that they were reasonable and necessary to the handling of my case. Or you can say, you know what, I agree with the amount that they're seeking, and I want to just cover the issue of an installment payment order. It's up to you. I don't want to put you into bankruptcy, but they do have the right to have their money paid.
Right.
And so you tell me what you want. It's entirely up to you.
My only concern was the large increase, and it caught me off guard. And I actually reached out to Mr. Eberth first.
Ma'am, if you don't want to settle this, you don't have to settle this. I can just set it for trial if that's what you guys want me to do. It does not matter to me. I'm not trying to pressure you into settling, not settling. I could care less. So I can't resolve that right now. If you think there's an issue that maybe you were overcharged, we'll just set it for trial. If you want discovery, that is the exchange of information. I'll be happy to give you dates on that. Whatever you guys want to do, it's up to you.
Well, I was looking for more of a settlement amount because I can't afford to pay the rate he was asking for.
Well, you signed a retainer agreement at that though, right? Did you not sign a retainer agreement?
I did.
You had to think about that before you sign the agreement. I mean, I know lawyers are expensive, but there's a lot of hidden costs. You know, they're paying secretaries and all these other, office rent, malpractice insurance, postage, phone bills, you name it. There's a lot to that, but.
And Your Honor, this was not a simple matter. It got very complicated, and there were they had reconciled at one point, refiled again, had a pretty extensive mediation. There's a lot of things that we would be presenting.
So where's his total fee?
Yes.
How much was his total fee?
Oh, his total fee. I don't know that offhand. I do know the outstanding balance, but
which is
over $9,000 at this point. It is.
Was there a lot of court hearings regarding maybe custody issues or something similar, ma'am?
The final 2 invoices were for mediation. We had mediation one time, and that was the $6,400.
Yeah,
that's why I was caught off guard.
They're paying mediators. They're paying the lawyers. How much did the lawyer get paid? Do you know, that mediated the case?
We paid the mediator on our own.
Okay. How many hours did he include for mediation, Mr. Eberth or his partner or whoever?
I believe it was 2.5 hours, 3 hours around there.
Oh, that's not much.
That would
But
be,
he and I paid the mediator directly. I didn't have Mr. Eberth pay the mediator.
as your honor probably knows, it's not just the attending mediation and showing up for a couple hours to talk.
Preparing
That's
for it.
Lots of that. And there's lots of communication in the we send out monthly statements, your honor, that detail everything that we're doing on a file. And she would receive these every single month. And
You tell me what you want to do, ma'am. Do you want me just to set it for trial?
I don't personally want to go to trial, but I cannot afford the terms that he was looking for. I can't afford the monthly
Okay,
rate he was
so
asking.
that's why I said I would come in. If you agree that you owe the debt, you two can agree to a consent judgment in that amount. I can have a hearing right now for installment payments. I will ask you questions. You can testify. He will ask you questions. I'll determine how much you can afford to pay on either a weekly, bi-weekly, or monthly level, or installment payment plan. And if that's fine, we'll continue that now. If not, I'll just set it for trial, whatever you want. I mean, you can't just say to me, Judge, it's too much money. You're not giving me a reason to say he overcharged you. You're not giving me a reason to say anything about the installment payment order because I don't know anything about it. I don't know how much you make. I don't know where you work. I don't know how many expenses you have. So let's take one thing at a time. Do you want a trial or do you want to settle at the rate that Mr. Lampkin agreed to? And I'm talking about the amount that he agreed, not the installment payment amount. I can handle that separately.
I think I was just in the mental space of Mr. Eberth coming to me with a settlement amount because of the amount. So accepting the amount is difficult.
I'll just set it for trial. Do you guys want discovery or not?
Short period. I don't know that we need much, but maybe it might help to know some more financial information for that portion of the trial regarding ability to pay once we determine what the balance will be.
Give you guys until July 18th to conduct discovery. There will be no ADR. Witness lists in this case are due on June the 18th. Nobody demanded a jury trial, correct?
Correct.
I'm going to set the trial again for August the 24th, and that'll be at 10:30 in the morning. At 10:30 in the morning. Nobody has to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. No voir dire questions, no jury instruction questions. I think that should cover it. Let me just see here. Two. Do you have any questions of me, ma'am? I'm going to send out this pretrial order. You guys should have it next week.
Yes, Your Honor. What was the July 18th date?
That's the discovery cutoff. If you want to conduct discovery, you have until July 18th. So if they have documents you might want to see that would bolster your case or defeat their case for attorney fees, then you can go ahead and submit that, whether it's discovery for documents, interrogatories, depositions. It does not matter, okay?
Okay, thank you, Your Honor.
Good luck to you both. Thank you very much. City of Dearborn versus Irvin LeBlanc.
Thank you.
Thank you.
2505282. And I want that other case here with Ms. Schneider and the defendant on that one. If you can, Teresa Roberts or whoever that was. Might have been Teresa Roberts. Your name?
Christina Hawkins.
Sir.
6 cars.
All right. Give me 1 second here. This is here for trial? You ready for trial?
We came to an agreement.
Your name, sir?
Urban Law.
Okay, what is the agreement?
We agreed to conditional dismissal effective and making payments of $100 a month beginning on June 30th, 2026.
And how much is the total amount of the judgment?
$978.03.
That's the total amount including costs
Yes.
and attorney fees?
Yes.
All right, so sir, she tells me, is this a conditional dismissal? Do you understand that she's telling me that the case will be dismissed? And that according to the terms of the conditional dismissal, you're agreeing to pay $978.03 at the rate of $100 per month, beginning June the 30th and the 30th of every month thereafter until paid in full. Do you agree to those terms?
I agree with those things.
All right. And does she have your permission to sign your name to that proposed condition?
Yes.
Okay. And does that have all the terms set forth?
Yeah.
Do you want to hand that up? Okay. Do you have any questions before I sign that, sir?
There's one thing I didn't ask her. So the insurance company is billed a different amount. So you'll just send me the matter.
Okay. Anything else?
That's it.
All right. You're all set. You can go down the hall and they'll give you a copy, both. Thank you very much. Where's Miss Schmidtke's?
Yeah.
All right, come on up here, ma'am. LVNV versus Carly Schmidtke, 2600660. All right, Ms. Schneider, your appearance
Lisa Schneider on behalf of the plaintiff.
and your name.
Harley Schlenke.
Any resolution?
No, Your Honor. This is a very, it's a small balance case, but the defendant is still arguing the service of process issue.
It has nothing to do with anything at this point. You showed up. You're not gonna get dismissed on a technicality like that. You're here.
Okay.
You understand what I'm saying to you?
Yes.
If you think you owe the debt, it doesn't make any sense to prolong it.
See that.
So you want to agree to a judgment and we can set up a payment plan for you?
I would like to do a motion for installment payments.
You don't need to do that. We can do all that verbally. I can handle that right today. I can swear you to an oath. And then you'll tell me what kind of debts you have, what kind of income you have, and I'll be happy to rule on that.
Okay, we can proceed with that.
So you want to consent to the judgment in the favor of the plaintiff and against you in the requested amount of $652.78 plus costs and attorney fees?
Yes.
Okay, so do you want to give me that breakdown now, Ms. Schneider?
The 652.78. I'm not certain what the court fees are.
You got a $55 filing fee.
I do have the process server fee.
How much is that?
That is, 1 second. I apologize. I am trying to get that.
Do you know how much it is, Jennifer? I don't have that on this sheet.
Your Honor, I don't have any of that because it's not our case.
Oh, that's
I don't
right.
have access to their M file.
I have it. I'm just trying to pull it up. It's just giving me difficulty pulling it up. It is $47.96.
So you have $102.96 in fees. Are you collecting you asking for the statutory attorney fee?
Yes.
And your principal sum is $652.78. So it should be $755.74 plus the $75. It should be $830.74 is the total amount. Do you agree to that?
Yes.
Does she have your permission to sign your name to a consent judgment indicating that you're going to pay $830.74? And then I'll conduct the installment payment hearing now, and we'll put that on a separate document. Is that,
Yes.
do you agree to that?
I agree.
And you agree that you owe the $830.74?
Yes,
Okay, so you're gonna sign her name to a consent judgment and you're gonna waive the notice requirement on the motion, correct, Ms. Schneider?
Yes.
Raise your right hand. You solemnly swear affirm. Under penalties of perjury, that the testimony you'll give in these proceedings will be the whole truth self you got.
I do.
Okay, ma'am, where do you work? You work at the 27th District Court?
Correct.
Are you full or part-time?
Full time,
How much, is your salary there?
18 hourly, 40 hours a week.
Eight?
Net income after taxes about 1,000 bi-weekly.
All right, so you make $18 an hour, you work 40 hours a week. You're saying your net every week, every 2 weeks is about 1,000.
Correct.
Do you have any children?
No,
Are you married?
no.
How much do you think you can afford to pay in whatever increments?
Honestly, with everything going on right now, I have student loan payments that are pretty high as well. I know that doesn't really matter for the record, but that's what's eating up most of my income.
How much you pay in your student loans?
Well, I pay about 500 right now.
Per month?
Yes,
And how, do you have a car payment?
no,
Do you own or rent?
I live with somebody.
You pay any rent?
I pay groceries,
How much do you spend in groceries
300,
per month?
yes.
All right, so you got 500 plus 300, you got 800, you're making 2,000 net per month. What other bills do you have?
I have my finances aren't really that great. I have like cash advance loans that I pay and personal loans that I pay. And that eats,
How much of that do you pay per month?
for right now, 500 a month.
All right, so you got, all right, what other bills?
Internet, 15 a month,
$15?
yes.
How do you get $15 a month?
There's a special program.
Okay, go ahead.
And then I have.
You have electric, do you have to pay any electrical?
No, I don't pay electric or any.
You sure get to fill your tank of gas, right? Which city do you live in?
Look at mine,
So you
and
don't live far from the courthouse, which is good, meaning you don't have to drive far.
Correct.
All right, what else? How much do you think you can afford to pay monthly?
I would like to do $50 a month starting in July.
What's your position on that, Ms. Schneider?
Your Honor, I was looking for a 10-month payoff, so it would be like 80, I guess 83 a month.
Can you pay $65 per month starting July the 1st?
Yes,
I'm gonna order that, 65 per month, beginning July the 1st. Will you submit an order to me on both of those fronts? You can put the consent judgment separate, then the order for installment payments. You have to stay up with those, okay? And you understand, even if you're making those payments, I'm just telling you, they could garnish wages. I mean, not wages, but bank accounts and tax returns. Do you understand that?
oh, I understand,
All right. Do you have any questions?
not direct.
She'll submit the orders and you're all set, and I wish you well. Best of luck.
Thank you, Judge.
Do I have Anthony Hall and Top
Ms.
Speed?
Schneider, Judge, if I may, Ms. Schneider, if you'd like to email those to me, being this is not our case, you can't upload them to M-File.
Oh, good idea. Okay.
Instead of sending them to the Wyandotte and then having them sent over, Jen at 33court.com.
Where are these?
Thank you.
You're welcome.
Okay.
Anthony Hall versus Top Speed Performance and Repair. And then I have a counterclaim, Top Speed Performance and Repair versus Anthony Hall. Your name? What's your name, ma'am?
Amber.
Amber what?
Smith.
What is your relationship with Mr. Hall? All right, congratulations. Did you talk to these guys?
Yeah, they were supposed to be here today, but they're on Zoom.
Why are they on Zoom?
I don't.
I'm on Zoom because currently myself and my son are recovering from being sick. I didn't want to come in and risk getting anyone else sick.
I thought I told you guys you had to be here in person. Didn't I say that? Am I wrong?
I actually have on a sticky note when I went to go and submit the copies of my forms that day. I believe it was one of your clerks that gave me the Zoom meeting and said that it was okay that I did by Zoom as well. I'm
I
sorry.
wrote in person. I don't write in person unless I tell them you have to come in person.
Oh, I do have the sticky note in her handwriting.
I don't care what she said. I'm telling you what I said, and I said in person. I didn't say you could appear by Zoom. If I'd have said Zoom, you could appear by Zoom, I would have written it down. So you're sick with what?
The flu. Didn't know. Just didn't want to be super contagious around anybody. And, plus Bobby Kelly.
And you are here for Top Speed Performance?
I am. I'm the owner.
And you were here before, right?
I was. Yes, I was there in person.
Didn't you have somebody else with you?
I did. He was unable to come today. For what reasons?
Did you bring who you
Unbeknownst to me.
guys need to bring to prove your case? I mean, listen to me.
Yeah, yeah.
Who?
Right here.
Well, wait a minute. Slow down a second. Is she a licensed mechanic?
No, but she talked to him on the phone. So she can tell me what he said to her.
Did you? Hang on. Hang on. So he didn't swap out all the components?
So what happened is,
Just tell me briefly, because I don't even know if I'm going to.
that's what I was paying him to do to swap.
How much did you pay him?
I ain't paying anything yet, but he was supposed to get $5,000. But he did not do the job.
Why are you suing him for $7,000 if he did something?
I gave him two motors. One motor was a fully built bottom with some heads that we sit on. Another motor came out of my cop car.
All right, hang on a second. Hang on. Did you call the court and tell us you were sick this morning?
I tried to get through, but I couldn't. I could not. I didn't know what extension to call.
Who'd you call?
I called Woodhaven. I just Googled Woodhaven District Court and tried to get through and couldn't get it through.
What do you mean? At what time?
It was 9 o'clock this morning. If need be, Judge, I have no problem. If you're okay with adjourning for a week or so, I'll come in
Mr.
person.
Kelly, here's the problem. I made these people come in here in person. They drove from Detroit. We have.
I live in Dearborn Heights myself.
Gosh, why do people think? I don't know why. It just to say, please interrupt me before.
I'm sorry. Excuse me.
Kel, there's no way that we blocked your phone.
Oh, I'm not stating that.
Look, don't. You didn't call at 9 o'clock. Don't make it sound like you're trying to get through to the White House here. We answer the phones. You tell me what phone number you called. You put it up there right now. You called on your cell phone, right?
No, I called from my wife's phone.
All right, go get her phone and I'll take a look at it.
She's not currently here.
You didn't call, did you, Mr. Kelly?
I did, Your Honor. I did.
Who'd you talk to?
I didn't talk to anyone.
What number did you call?
I would have to Google it. Like I said, I Googled the phone number.
You have your phone?
Yes.
Why don't you right now go online and call your wife? Well, I'll stay right here.
Ugh.
Call your wife and find out what phone number she called, or you called on her phone number. She can read it back to you, right? We all want to do that. Right?
Okay.
You didn't call, did you, Mr. Kelly?
I did call, Your Honor.
You did, but we just didn't answer the phone?
Well, I don't know what it was. Listen, I'm an Android person. I have an iPhone now. And every time I try to make a call, it's blank. I call back, there's no sound. So that's my issue.
Did the phone ring?
It did not ring. It was just silent.
We didn't have any problem with our phones this morning, did we?
I don't think it was a problem with your side. I think it's my side.
No, Your Honor, not that I'm
You
aware
didn't
of.
call, did you, Mr. Kelly?
Your Honor, I did call.
Do I have to have you call your wife while I'm on here and find out whether or not you called?
I mean, my wife can, if you need be. But what I'm saying, Your Honor, is like I said, if you want to, if this is a thing, we can. I don't have a problem adjourning and coming in.
Adjourn it for you for 2 weeks, and you're going to pay them costs. You can pay him costs of $150 because you should have at least called where we could have called him and told him, and then he wouldn't have to drive from Detroit. I wouldn't want to drive from Detroit or Monroe or any other place that's a half an hour away. That's an hour portal to portal. Why would he want to waste his time doing that?
Well, if I wasn't sick, I'd have been there. You know,
Sure.
I'm not
Sir,
this.
Sir. Case adjourned 2 weeks. Defendant to pay $150 in costs to plaintiff at his address at 10426 Aurora in Detroit. That's it, right? Right? 48204. You're going to send it there. You have that address?
I do. I have it. If it's accurate on his paperwork, I have that.
You're going to send it by May the 27th. He needs to receive it by May the 27th. We'll reset this for June the 1st, Jen?
Yes, Your Honor, at 10 o'clock.
At 10 o'clock. Okay?
Okay. Check. Okay.
Yeah, check's okay. Just make sure it clears. If not, that's a crime.
Quinte.
That's
Mr.
Eckert. I believe Mr. Eckert.
Sonny took a big breath there. He's taking a deep breath.
Today. He's in jail.
He what?
He's in jail. But here's the thing is, it's coming. I think we got it worked out. So I'm going to talk to the governor and see if we can get it set this week.
Why didn't we get Quinte here?
He wasn't logged as in jail, but
He's on bond.
no, sir, he's not.
He's in jail now.
Yeah.
When did he get in jail?
He's been in custody for over 400 days. It's a mistake that it wasn't docketed as a jailhouse charge.
It's
So do we bring him tomorrow?
We can bring him anytime this week as long as.
Let's get him before he changes his mind.
I'm going to talk to Erica because she'll have to be here for it. That's the whole catch with that. Is he's an interpreter.
See.
So I'm going to talk to her before I leave today, and then we'll.
Yeah, let's get this before people
But it
change
is
their mind.
it is a definite plea general.
So.
What that means. It's, you know what, when you say definite plea, that means it'll change tomorrow.
Yeah, it could.
I've already checked. They're pretty booked.
They normally, what's the plan? What do you?
It's a deferred.
Oh, well, yeah, they want to get him out of there. I mean, I can imagine the jail wants to do it.
It's a hold for us.
Something else?
He's had to.
So, but we're going to try to get him tomorrow, maybe?
Let's say this week, Judge.
By Wednesday, please.
Yes, yes, I'll make a phone call, you know, what I can do.
And you know his own crap. You know, I'll give you a call when they tell me that. I know that'll never happen. Yeah. I'll call you. Yeah, sure. That never happened. I promise I'll call you next year. Joseph Lewis. Yes, ma'am. Oh, that's 4 of these.
Yes, Your Honor.
And well, then.
Judge, it's actually only 3 cases. One of those was re-indicted. So I did the dismissal on that this morning. There was actually 2 re-indictments and 5 cases total, but now there's only 3 because the 2 re-indictments have been dismissed.
Okay, what's left?
26, all the 26 cases are left.
So what's next?
I'm getting evidence, Your Honor, because some of them I had not received notice that I was appointed on those cases. Because one of them, 26 DCCR 0060, in the portal, it showed Jason Nix. And I wasn't even aware of the two of them. They were re-indicted,
Were
but
you retained?
no, Your Honor, I was appointed.
Well, how did Jason get in now?
Mark DeRuman appointed him according to the portal on 1/20/2026. So
The state has now shared discovery in all of the cases, but
And so when can we be ready? I'll just need to know that.
4 weeks.
yeah, that would be fine. That would give me time.
Which one are you gonna try?
Probably
Have you
the
decided?
possession. I haven't decided yet. So
It goes back
25,
to Don Dusler. Even
25.
back another step. So 74 is going to be dismissed.
yes, I've sent you the dismissals on
And-
0374 and 0494, which is not currently on this docket.
Legal possession of substance, and that's second degree felony with an enhancement. That's a 060. Three, it's a state jail bond. And then 324 is a third degree felony with that enhancement. So this is the same. Same as this one. Well, these are all on 3 different dates.
Yes,
East
Judge.
Coast and Bond, I guess. All right, PCP, yeah, we're gonna do this inside with E first. On 060, that's enhanced.
Fine,
And he's ineligible for probation, so.
That's correct, Judge.
All right, then that will be set for trial as soon as we can get it, okay?
Thank you.
Okay, thank you, Your Honor.
Thank you. Cody, yes, ma'am. Thank you.
Excuse-
Yes, ma'am.
Thank you, Your Honor.
Cody Garrett. Hey, y'all, over here. There's Langston. I am. 5, I repeat 5 places. What are we doing on this?
He's in
5 and 5 of these? All right.
Well, anyone that we try is going to involve evidence on all the others.
Okay.
So
Cody Garrett.
this one's going to be involved. It'll take at least a week to try.
Doesn't scare me.
I'm just advising you.
It's all, it's what, if it takes a whole week, do you mind if you just think off on one day and then you Thursday? It'll be say I asked just to not do anything and come back. You know what I got going on this Thursday.
What, when? This week?
This week. That's
I think we got something else going this today, don't we?
We have one with Langston that's ahead of it, Judge, and possibly a second one.
We're not even through with the docket yet.
And when I say just that one day, if we can just give me that one day and we'll come back, and that's something that if you make.
I would prefer a reset. I don't want to break this up, Judge. I've got, in addition to these 5 cases, there's some others that I'm researching that I need to put together on this as well.
I'm not going to JP as much as we want. And I do it, I just have to, I just want to one day, Judge, and I can come back to that day.
And they're a little upset in the back.
They heard I was their lawyer.
I bet you that's what's the rain, you know, doing.
Burglary. Is it the burglary we're gonna handle first, the first degree felony and burglary?
The one with the biggest punish range is 485, because that's burglary with the intent to commit a sexual assault.
That's what I'm saying. Burglary, habitation, 485, that'll be set first, okay?
That's the one I'm announcing. But again, Judge, this is one that's going to involve.
How much time do you need to get ready?
Sir?
How much time do you need to get ready?
A regular set will work on this.
You be crazy. 4 weeks. Okay, 4 weeks set for trial priority. On okay, Yamuel Burgos.
Nope.
Mr. Gilford. What? Does anybody know anything about this one, Mr. Laird?
You don't know.
Wish the defense attorney was around. They come in handy in the docket. Have you heard anything from him? No?
I haven't done.
That's disappointing. Okay, 7 with file docket. Y'all ready? Michael?
I can be, but I don't think the defense attorney has some of the discovery, some of the media discovery. Yes, sir.
Trial.
Yes, sir.
Christopher Dines. Kimmler, one of Kimmler's. All of those are going to be reset one term to the next trial docket on his. Xavier Turner. Mr.
We're asking for a mental health competency evaluation, and based on my interactions with him, he probably needs one. So I've told Ellie I was going to file a motion, but it'll be an agreed motion, so I don't think we even need to have a hearing.
Help you? I'm sorry, I can't hear you. Keep in contact with your boss.
Okay, so 25 CR 1373, that's an habitual felon, right?
Yes, sir.
On that one. And it's a 3rd-degree felony enhanced to a 2nd-degree felony on 269, and then finding this other 70 was 3rd-degree felony with an enhancement, one enhancement, but it's the assault on a peace officer.
Yes, sir. That's the one that's habitual.
What we're going to be going on.
Yes.
All right. What are you going to do on this one?
Judge, he
You need
wrote
to file something.
Yes.
Okay, get it as ASAP, and we'll get it, Dr. Rapon to evaluate, and then we'll move from there. Okay.
Thank you, Judge.
All right. Sonny, get that one. You can work on it this week.
Yes, I'll do that.
Thanks. Oh, Tom, on Darren Patterson. What are we gonna do?
He was here.
And where is it?
Well,
He was here.
I think he's going down.
Yeah. He's going down.
Take a vacation down the county. You know what? He had an accident.
Okay, well, we need him for a trial doctor.
Yes, sir. He was placed in custody.
Did he leave?
He's not here. The warrant division took him to jail.
Well, they're certainly aggressive today. So what do we,
If we could reset that one, Judge.
well, I'm trying to find out what we're gonna try, and I'm not sure what we're gonna try, and we're running out of cases.
I think
But
Mr.
Are y'all ready to try?
Mayor is ready.
You're not. Okay, I've got, and remember Kindler's out, so that wipes out about 4. And so we've got Darren Patterson, There's a Jim Bailey with Langston that they say is ready, but it's assault family violence. As you know, what those end up being sometimes, we don't get to try those. Xavier Aguilar, we need other stuff. That's Joe Vasquez, and you're ready.
Your Honor, I have a motion to re-examine Mr. Aguilar.
On the day of trial?
Well, I thought it was several weeks ago. We were betting, come out and visit.
When you got it presented, Joe. I mean, it goes in 5,000 files, and I don't see it until there's a docket. And then we deal with it when we should have dealt with it earlier, and we could have been ready, Please do that. If it's going to be something like that, like it's competency or any kind of evaluation, present it to me. So I don't want to just languishing. And here we are. Can't do much about it today, if that's what you're going to do.
I'm willing to.
But
He's been saying
it's 2 years old. He just became incompetent?
Yes, sir. No, he passed with flying colors, mine does, but he'll never come out and visit me. I'm sure I filed that.
Well, and maybe he's just antisocial.
I told him this time that before.
Yeah, this was fine. See, it gets in the file, and it was filed over a month ago. But I don't know about him. Was he a felon?
Yes.
This number? I've been fishing. Oh, they're fixing.
I'll give it a go. A really well reduced all for the trial to get this case in which to the judge. Yeah, Your Honor, I don't think it's a trial, I just don't know how to proceed. I'd ask the court to speak with us.
I'm not gonna speak to him. We'll see all about it. That's a decision y'all have to make. I'd love to speak to all of them, but I don't think I should. 2806, there isn't.
That discussion may reveal if he's competent.
Sorry?
That discussion might reveal if he's competent.
Okay, he was evaluated a year ago. And
What time are you going to give me? If we go. If we go, we're going to go this afternoon, we can go over these. 8 o'clock tomorrow, and we'll go back.
And what is it you're saying leads you to believe he might not be?
He'll never come out. Oh. And ask him about this.
Well, that's the strategy, I guess, huh? As long as you don't come out, then you can do your time at the county jail for the rest of your life, I guess. Bring him out. Let's see what happens on Xavier Aguilar. Does he speak English fluently? How do you know? He's not talking to you.
He talked a little bit.
That's a test.
He talked a little bit this morning.
Gotcha.
He's a real hard now.
Tom Barber said, this is what you do with Joe this time. He won't talk to me. Ask him if he said to talk. Oh, sorry. What language does he speak? Is that
It's a
a muted form of English. Where you just can't do it.
Standing birth, Jack.
Come on up. Oh, boy. You hadn't gotten your haircut in a while, huh?
Nice to see you,
Sir, do you need to get your hair cut over at the jail?
Yes, sir.
Okay, we'll help you with that, okay?
Yes, sir.
Get you, yeah.
Yes, sir. Lieutenant Morgan, I'm sorry. You're gonna do it.
Okay. You are Xavier Aguilar.
Yes, sir.
And you're charged here in this offense with assault on a public servant, sir. And Dr. Edgar Pond evaluated you last year for competency and declared you to be competent. And today is the trial day.
Yes, sir.
And so we're going to get you dressed and get you ready for trial, okay?
Okay.
All right, you see Joe here, Vasquez? He's your lawyer, you know that. All right, you want to talk to him before the trial, maybe?
No, sir.
You ready to go?
Yes, sir.
Yeah, okay. You've studied on your own.
I have service.
All right. Do you understand completely what you're charged with here, though? You're charged with a third-degree felony of aggravated, I'm sorry, assault on a public servant, which is a third-degree felony. But the indictment goes on to allege that before you committed that third-degree felony, you were convicted in 2020 in Montgomery County for the second-degree felony of illegal possession of a controlled substance. Do you recall that event?
Yes, sir.
After that was filed. Oh, I'm sorry. That was December 20th, and that cause number, and it's 20-02-01978, which is the way they numbered things in Montgomery County. After that conviction was final, paragraph 3 of this indictment alleges that you thereafter committed another illegal possession of a controlled substance, a second-degree felony, and you were convicted of that on June 20th of 2023, also in the same 359th District Court in Montgomery County, Texas. You remember that event happening?
Yes, sir.
After that was final, it is alleged in paragraph 1 that you then commit the offense alleged in paragraph 1, a third-degree felony of aggravated assault of a public servant. If you were found guilty of this aggravated, this assault on a public servant, rather the third-degree felony, and it says that you caused bodily injury to the public servant by striking him in the face with your hand, and he was apparently, I guess he was a jail security official, so he must have been a jailer. If you were found guilty of that crime, if it were found true that you have these prior convictions out of Montgomery County that of illegal possession of a controlled substance, then you were looking at what we call habitual felon status. Your punishment range would be no less than 25 years in prison, a minimum of 25 years in prison to life in prison. It's the most serious type of punishment other than, I guess, capital punishment. So do you understand what you're facing here, sir?
Yes, sir.
Oh, have you talked to Mr. Vasquez about whether that could be resolved without a trial or not? Because that's what we're here for. We're going to try this case unless y'all can reach an agreement with the DA's office. Have you thought about that? Why don't you talk to him and just find out what the options are, and then we're going to do whatever you want to do, okay?
Yes, sir.
Yeah.
Okay.
Go ahead.
All right, I'll go ahead and put it on the record that I was going to waive his priors and agree to a 5-year sentence. As far as that's the plea bargain agreement.
Y'all go back and talk, okay? Xavier?
Yes, ma'am.
And so do you understand what he's saying? It's going from, if we go to the jury, you're looking at a minimum of 25 years imprisonment if found guilty. And they're offering 5 years with credit for time you have served in custody in regards to this, which I'm not going to influence you, but that's a most generous offer. But at the end of the day, it's your choice. Whatever you do, we're going to take that route, okay?
Yes, sir.
All right, talk to Joel and come back and let me know what y'all do because y'all are up here for trial. Okay. Thank you. Do I have any pleas in the queue?
You should,
Yeah.
You've been cited, so.
Rolando Martinez and right at Lincoln.
Yeah.
Armando Martinez, por favor.
Let me just swear.
I was doing it to impress you.
You did great, Jack.
Muchas gracias.
De nada.
It doesn't matter what.
That was Spanish, by the way, we were speaking.
Yeah, it doesn't matter what language you do. I've been here around the world with you.
And I'm proud of it, too. I'm proud of that. adventure you and I have had.
There has been.
Here it comes.
You gotta have a finger right this way, second. Right around.
Is it flying on the box?
Let's go on the record. Is that go on the record?
Everything goes on the record, hearsay. Which means you're in deep trouble.
I know.
What can I say? You've always been.
You drop a deep way. Thank you.
Thank you. Making that type small. Let's see. All right, we call cause number 23 CR 1653, the state of Texas versus Armando Martinez. And the defendant is present with his attorney, Mr. Burbank. The state's attorney is present. And Mr. Martinez, I believe, is fluent in Spanish. And Erica Burge, our great translator, who's is fluent in English and Spanish and has translated officially for us numerous times, is present to help Mr. Martinez. Ms. Burge, please raise your right hand. Do you solemnly swear or affirm that you will well and truly and accurately translate from English that we will be speaking into Spanish, for which Mr. Martinez is most fluent, and then his Spanish responses will be repeated into English for all of us, and the record shall reflect through the court reporter. Will you do that accurately? And I know you will professionally, so help you God.
Yes, Judge.
Lower your hand. You are Armando Martinez.
Yes.
And you were here with Mr. Burbank, your attorney, and the state's attorney is here, the prosecutor. You are going to be entering a plea today to this offense as alleged, correct? No. What are we doing?
Let's include of manslaughter.
Stand by. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
He does, in your honor.
In summary, this indictment, as it is alleged, that was handed up by the grand jury in October of 2023, alleges that on or about September 18th, 2023 in Jefferson County, Texas, you committed the first-degree felony of murder. Do you understand what you are charged with here in the indictment?
Yes.
Yeah.
Yes.
An agreement has been reached between the parties that you would be pleading guilty to the lesser included offense of manslaughter, which is a second-degree felony. Is that your understanding of the plan?
Yes.
All right. The crime of manslaughter is found under section 19.04 of the Texas Penal Code. And this provides that a person commits an offense if he recklessly causes the death of an individual. Do you understand what manslaughter is, sir?
Yes.
This is a second-degree felony, which means if convicted, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
An agreement has been reached in your case where you would be pleading guilty, found guilty of the second-degree felony of manslaughter, and sentenced to 5 years in prison. Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this lesser included second-degree felony of manslaughter under this murder indictment in this cause number 23 CR 1653? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty? Because you were guilty.
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document? Did you understand it and discuss it with your attorney? It was translated to you from English to Spanish, and then you spoke with your attorney. Is all of this on State's Exhibit 1 true and correct? State's Exhibit 1 is tendered into evidence. Without objection, it is admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. When indictment's been read to you, you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you are totally satisfied with the representation provided by your lawyer. All of this true, it states, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
We ask you what
I'm going to follow this agreement, if nothing further, and I'm going to find as follows that in this cause number 23 CR 1653, the state of Texas versus Armando Martinez, the defendant was charged with the first-degree felony of murder. He has pleaded guilty upon a plea agreement reached between the state of Texas and the defense for a guilty plea of the second-degree felony of manslaughter under this indictment. And I'm going to find that the defendant has pleaded guilty to this lesser included offensive manslaughter voluntarily, knowingly, intelligently.
I think he's a citizen. I don't know if we covered that or not.
There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt of this lesser included offense of manslaughter. Stand by. This, going back on this written agreement that is part of the plea agreement that you signed and admitted to, that was State's Exhibit 1, among other things. State's Exhibit 1 states that if you are not a citizen of the United States, a plea of guilty and a conviction may result in your deportation, exclusion from admission to the United States, and or denial of naturalization under U.S. federal law. Do you understand what I'm saying? Are you a citizen of the United States?
No.
Okay. Do you understand that a plea of guilty and a conviction under manslaughter can affect your ability to gain citizenship under the laws of the United States? Do you insist on continuing to plead guilty to this lesser included second degree felony of manslaughter?
Yes.
See, yes. Okay. I'm going to follow, this agreement. Anything else is a pre-sentence report waived.
We waive, has to be waived, nothing.
If nothing further, I'm going to make the following findings. That Mr. Martinez, you are pleading guilty to this second-degree felony of manslaughter, a lesser included offense under this indictment of murder. You are doing that voluntarily, knowingly, intelligently, and based upon discussions with your attorney. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this lesser included second-degree felony of manslaughter under this indictment. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a handgun, was used in the commission of this offense. Do you understand what has happened today, sir?
See.
Anything else to add?
Nothing, sir.
Defense state. All right. We're in recess on this. Thank you.
No. Well, you're one here. Chris, I know about this. Would be a way baby. While you're in trial. Wait, baby. Mom. He goes, you just put me off the trial. Now, what?
Here's this one. How is this? Like Judge Walker?
Yes, sir.
Are y'all ready?
Your Prince is in, Judge.
Okay, let me know when you're ready.
We're ready.
Oh, you are?
Oh, we are ready.
And I don't have any papers.
I'm signing it, Judge.
Oh.
I just got it.
Okay.
I'll just need him to.
Yeah. Thank you.
And I look at what it is. It is, it's not Johnny. Yeah, she's so too loud. No. It's not like that.
Bird song.
So, there's just materials and things still. You're good. No, here's the Jenny going. They will film the job. There we go.
Yeah, Logan Bird song.
Yes, sir. He's your judge. Really sorry, I'm like.
The right song. You just raise your right hand. When I arm, got a bit confused, nothing but yourself. Right, into your right thumb.
He's a big dog.
Flatten down the bottom. You get up one more time. Place it
Yeah,
flat.
we're going another, oh, really? We've come from a wedding out of the Port Arthur Country Club and strolled in late and then couldn't even find the family. And then they were on the other side. We were on the left and then got to the right. And then we had to go, you know, it's, They change so fast. And that's such a special time to see them. And look, here's the deal. I couldn't, there are like 3 or 4 kids up there that look the same. You know, they're in the, and what it happens, they're little children, and then they put on makeup. They got the makeup and they're 7, 8 years old, and they all look the same when all the makeup's on. Well, which I was asking Muskie, which one's ours? But those are special. They change so fast, you know. Actually, you know. All right. We now call 24 CR 341, the state of Texas versus Logan Kyle Birdsong. You are Mr. Birdsong, present, with your attorney, Mr. Walker, a great judge, and then the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in sum?
Yes, sir.
Let's see. Looks like we got a lesser included going here, right?
Yes, sir. Seems to be my day for it, currently.
Well, you're probably going to be a popular guy then, if this is your day for lesser included.
Yeah.
That tends to get the attention.
It just happens to fall that way on the docket this time.
Okay, we're going to do like the previous case, second degree felony.
Yes, sir.
And again, does the defendant waive a formal reading of this indictment? We can proceed in murder.
He does.
The murder indictment and proceed in summary.
Yes, sir.
In summary, sir, this indictment alleges that on or about December 7th, 2023 in Jefferson County, Texas, this indictment states that you committed the first degree felony of murder. Do you understand what you are charged with?
Yes.
Okay. An agreement has been reached in your case where you would be pleading guilty to the second degree felony, the lesser included offense of manslaughter under this indictment. Is that your understanding of the plan?
Yes, sir.
Under section 19.04 of the Texas Penal Code, it provides the elements of the crime of manslaughter. A person commits an offense if he recklessly causes the death of an individual, and an offense under this section is a felony of the second degree. Is that your understanding of what we are doing here today, sir?
Yes.
If convicted of a second degree felony, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand, sir?
Yes.
An agreement has been reached in your case where you would be pleading guilty, but not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500. And is there any restitution here in this? Okay. Is that there would be terms and conditions of probation which are normal and customary for the circumstances of this case. Is that your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this second degree felony of manslaughter, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
Okay.
And without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. Do you understand what you're charged with? The indictment has been read to you, or you've read it. You were guilty of any lesser included offenses, as well as you could be prosecuted for the indicted offense. Manslaughter is a lesser included offense of murder. that you have pleaded guilty to in this case. And you were totally satisfied with the representation provided by your lawyer, and you were giving up all rights to a trial and moving forward in this manner. And is this what you want to do? All right. State's Exhibit 1 is tendered into evidence without objection. It is admitted. Pre-sentence report is waived.
Yes, sir.
What I'm going to do, though, is order a post-sentence report. Place him on probation here, get a post-sentence report to come back, and then we'll figure out what terms and conditions of probation are in the best interest of all concerned. All right. If nothing further, I'm going to find you, sir, have pleaded guilty to this lesser included second-degree felony of manslaughter voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. And even though there's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this manslaughter lesser included offense, I am following this agreement. You will be placed on deferred or unadjudicated probation and not found guilty so long as you follow these terms and conditions of probation. Make sure you do. We're going to talk to the probation officer and you get squared here with the plan for the post-sentence investigation and report. Please make sure you follow these terms and conditions. And look, there's 35 of them, but I always tell people about 30 of them, all of us have to follow. So. Probation officer will review with you all of this. And there's a premium on making sure that you follow these terms and conditions of probation, because if you failed, your probation can be revoked. You can then be found guilty and sentenced up to 20 years in prison. Do you understand?
Yes, sir. See if this is RSG.
Yes.
Hensley, Braden Hensley,
Over here, sir.
that's you? Yes, sir. Okay.
Which right hand corner, please, sir? Swear or affirm, the other people, yourself, you talk. Okay, and go to the right hand front. Place it flat on the wall. Take your hand on house. Yeah, place it flat.
We got a lot of pleas from you today, Judge.
Yeah.
Doesn't change.
I know, right?
It is good. It is good. Things.
That'd keep you guessing.
You see how I do the attachment to it?
Yeah, I got it. Just turned it in.
Right, we now call 24 CR 515, the state of Texas versus Braden Hensley. And that is you, sir?
Yes, sir.
Present with your attorney and the state's attorney, Mr. Wilkerson. Attorney is present, Mr. Wilkerson, as the defendant's attorney does. The defendant have a formal reading of this indictment and arraignment. Can we proceed in summary?
Yes, Your Honor.
In summary, sir, this indictment alleges that on or around November 4th, 2023, Jefferson County, Texas. You committed the third-degree felony of illegal possession of child pornography. Do you understand what you're charged with here?
Yes, sir.
This is a third-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement has been reached in your case where whatever sentence shall not exceed a cap of, is this a 2 or a 7?
This is the 7, Judge.
It's supposed
It's not the Arabic 7 that okay, here's what I'm gonna do. I'm gonna put a little.
Concern is that Judge Wallace conducted an evidentiary hearing on the February 5th, 2026 date, and following that made findings of fact that served, the findings of fact served as the basis for his making the order in the case. Now, for me to change that order would basically retry the entire temporary motion, and it seems to me that the more appropriate matter would be to reset this in front of Judge Wallace, who is here next month, and would be able to consider your motion to set aside or to modify his prior order.
And if your honor's inclined to do that, I'd be okay with that. I just, he didn't have, no matter what Judge Wallace did or did not hear, we know Mr. Thomas was not present, and there was no inquiry in regards to his ability to pay at that time.
Well, I'm disinclined to go behind what another judge has found and ruled upon, because there may be some other factor that, that wasn't made apparent to me.
And
you had Judge Wallace's calendar.
Salmon depositions. Looks like I'm available June 16th.
Well, I think that's, I'm sorry for the inconvenience, but it clearly seems to me that Judge Wallace needs to consider a motion to set aside or to amend or change the order that he did after an evidentiary hearing. So we'll reset you for June 16th.
Would your honor be inclined to entertain the other motions in this?
Well, if you're going to go in front of him on any of them, I think you need to hear him. He needs to hear them all. So.
And there is an emergency motion we filed for immediate relief that's set for today. Mother there was a child, she was pregnant at the time of the last hearing. This child's since been born without any notice to father. This child has been removed from the mother, placed in an adoptive family in Colorado.
I did read that in the file.
Father was served Friday with a petition for adoption. Father's got 35 days, according to that Colorado summons, to file documents in Colorado contesting the adoption.
Well, let me ask this question. There was an order for DNA testing. Is that because there was some question whether he was the biological father?
With respect to both children.
And if he is the biological father of this child that's now being put up for adoption, obviously he has a vested interest in objecting to that. We'll go forward on that particular issue because I think there is an emergency basis. Why has there not been the DNA testing?
And that's why we filed the motion to review DNA testing. Again, Mr. Thomas was represented by previous counsel. They had entered an agreed order to participate in the DNA testing. The order required the testing to be scheduled by the father. There was some exchange between counsel about setting up the DNA testing. Mr. Thomas notified me he was going to any lab now. There was no specific place set forth in the order to do the DNA testing. Mr. Thomas noticed me. He was going to any lab now. I subsequently noticed opposing counsel. There was no objection made to that. The DNA testing was done and paid for by Mr. Thomas there. And then shortly thereafter, mother stated that she would, I guess, not be able to do the DNA testing at any lab now and referred us to an email that was previously sent over saying, I believe it was another lab, DNA lab North America would be more convenient for her. So it just seems like every time we get close to getting DNA testing done, mother is trying to interfere with that. Now we have a child in Colorado. I don't know how we do the DNA testing with the baby in Colorado. Mother has voluntarily taken this child or let this child be taken. I believe she relocated to West Virginia due to abuse allegations that were prior to my time. There was an agreed order I saw in the file entered between her previous, Mr. Thomas's previous counsel, Mr. Black, allowing her to relocate. The child, I believe, was born there in West Virginia, and she subsequently has taken this child and placed the child in Colorado without any notice to the father. The first time he's heard of this child being in Colorado with these pre-adoptive parents was Friday when he received service of this petition. So we had filed the motion to review DNA testing today because we're having an extreme difficulty in getting this done. This order was entered, I believe, 2 or 3 months ago, maybe even longer ago than that, and we still don't have DNA testing done. I don't know how we accomplish it now with a child that's in Colorado.
Parties are before this court, and therefore, one option is that I simply order that the child, the mother, and the father all appear at a lab here in Tennessee, submit to the DNA samples being taken, and then we go from there.
And that's what we're asking the court for today, is enter a more clear order directing the parties regarding the DNA testing. Judge, with respect to the emergency motion for immediate return of the minor children, both of them, again, there's an issue with paternity that should have been resolved. It's not. I hope we can get that resolved very quickly. But mother has taken this child, and I would submit that the children are subject to this court's jurisdiction. I know the child wasn't born here, and opposing counsel might make some UCCJA arguments about it, but I believe this court has jurisdiction over the custody of these children. There's a pending divorce. This happened during the pendency of this divorce proceeding, and mother relocated voluntarily and is now attempting to just go behind the father's back and have this child adopted. If this is father's child, he absolutely asserts a right to custody. He wants to be the father. Mother surrendered and voluntarily terminated her parental rights. That's fine. Then the court needs to enter a 365-0 plan awarding custody to the father because he wants to be a father if he is indeed the biological father. So we're asking the court today for some immediate temporary relief, and that brings us to the other minor child in mother's care, custody, and control. We don't know. There's an order of protection that was entered and subsequently appealed by father that the court's reserved for final hearing.
And where is that? Is that in this court or is that in a different court?
It was originally in general sessions. They had a hearing, is my understanding, and then that was entered and appealed. So there's still an order not allowing Mr. Thomas to have contact, and he cannot have contact with Scarlett Thomas. I believe she's almost 2 or 3 years old now. But we're asking the court to return both of the children to father. We don't know what mother has put a child up for adoption. We don't know where Scarlett's located. We don't know how she's doing. We don't know if mother's a fit and proper parent to have sole custody of Scarlett. She has given the other child up for adoption. And so we're asking the court for a more clear order regarding the DNA testing, to order the parties to have DNA testing completed within a specific amount of time. And we're asking the court to enter an order to have baby Thomas brought back from Colorado to Tennessee and to have Scarlett Thomas returned to the father. I think it's a threat of irreparable harm that this child's outside of not only this state, but in Colorado. Mother, by the attachment with what father was served on Friday, it is clear mother has consented to the termination of her parental rights. So we're asking the court for that emergency relief today.
Your Honor, I do have a response on both of those. Would you like me to tackle the DNA testing or the emergency?
Let's start with the DNA testing.
Your Honor, so the DNA testing, so my recollection of events and what has happened is that there was an agreed order between Ms. Thomas and Mr. Mathis. So Mr. Thomas's prior attorney, that was last year. Subsequently, Mr. Mathis withdrew. There was no contact between us. Had to hire a personal process server to actually serve Mr. Thomas some documents to try to find him. At that time, Ms. Thomas was absolutely willing to do DNA testing. And there was just nothing until very recently. There was a renewed push for the DNA testing, which Ms. Thomas is willing to do. I will point out to the court that Ms. Thomas is in another state due to domestic violence, which Mr. Thomas was convicted of in General Sessions Court by plea of guilty. She is in another state due to violations of an order of protection for multiple house break-ins, for following her to a medical facility and taking her vehicle. These are the reasons that Ms. Thomas is out of state. And so in an effort to preserve Ms. Thomas's undisclosed location, a essentially secret address, we were trying to coordinate DNA testing that could occur both locally here and where she was located. And that is why I proposed LabCorp. My understanding is when I had proposed that is the testing location we were going to use. And then I received communication that is not the testing center that was used. And then at this point, we reached an impasse.
So are you saying that LabCorp is available to do the testing both for Mr. Thomas here as well as for your client wherever she may be living?
So here as in Hendersonville, Your Honor, and where my client is living. That was our proposition. I will say that while I have nothing to give the court at this exact moment, my understanding is that the newborn child of this marriage is located in Denver, Colorado, which I found out about, to make it clear to the court, found out about Thursday evening.
Who is the father of that child?
So Ms. Thomas is going to say it's Mr. Thomas. I believe Mr. Thomas wants the DNA tested.
So we're going to, the order went down only as to Scarlett Thomas.
That's my understanding.
And there was a DNA request as to that child. And now we have another child born, and Mrs. Thomas says that is Mr. Thomas's child.
Yes, Your Honor.
And she has placed that child for adoption.
That is my understanding. I will say on Ms. Thomas's behalf that there appears to be some evidence that this was an understood plan between them when they found out that the child was going to be born. That actually, according to Ms. Thomas and perhaps some messages she would admit at hearing, Mr. Thomas has spoken to the adoptive parents before, that there was some dispute over whether they were going to raise this child or not. And at this point, Ms. Thomas could speak for herself.
Well, if there is an afterborn child that was born while this case has been pending, then this court has jurisdiction over that child, regardless of what has been filed in the state of Colorado.
Well, Your Honor, I will say simply for the fact that I do not want to waive any jurisdictional issue, and I've not had time since this was emergency order filed. I would like to file the detailed response. I will raise a jurisdiction issue just to preserve it under the UCC JEE. It's not so clear which is the home state, because the newborn child, if we parse them apart, right? The older child, absolutely concur with Your Honor. The youngest child, there may be some dispute over what is the home state. I have been informed that the state of Colorado has decided that they have jurisdiction and they are proceeding with this adoption proceeding. Again, I'm in candor to the court. It's a complicated issue to me, and I would need to file a brief and research that to give a response. But I do want to raise the objection that for the youngest child may not be the home state. But besides those things, Judge, I would also say,
you cannot divest this court of jurisdiction.
Understood.
By sending a child that is one of the children of these parties with a pending divorce action where custody of one child is already at issue, and then send one of the children that is alleged to be the biological child of Mr. Thomas. You cannot then send that to another state, that child, and defeat the jurisdiction of this court to make a custody determination. So I just want to make that clear, that this court's opinion is that this court has jurisdiction over both children if they are in fact the children that were born of these parties. And that is what I'm told by both of you today. So I'm of the opinion that Mr. Thomas needs to contest the adoption. And if he does contest it, contest that adoption, I'm going to put an order down that's going to require both of the children to undergo DNA testing. How that is accomplished is going to be up to you and your client. That means that she's going to have to ensure that that child is coming back and is tested. Now, we had a case not too long ago in this court where there was a woman who claimed to be a biological heir of an estate, and she lived in Washington State. There was a method by which she used a laboratory in the state where she lived to obtain her DNA sample. Then that was compared to DNA samples that were tested here in Tennessee. It would seem to me that's what's going to have to happen here. You're going to have to obtain a DNA sample from this child in Colorado and a DNA sample from your client and her child, if she, wherever she is living. And then a sample will be taken from Mr. Thomas here at LabCorp. And all of those are going to have to be analyzed by LabCorp to determine the paternity issue. The order that this court puts down is that this court maintains jurisdiction over the parties and both minor children who have been represented to this court by counsel to be the biological children of these parties. And that the adoptive court in Colorado, there may, obviously this is going to be an issue for the appellate courts if it goes through as a contested matter, but I think we got to first resolve if this child in Colorado is Mr. Thomas's biological child. If it's not, then there's no issue. If there is, then he has to take the steps to contest it there in Colorado. He cannot ignore the Colorado proceeding and rely upon this court's ruling, because Colorado may say, you know, we don't care what Tennessee does. We're holding that we have jurisdiction. I'm ruling, I don't care what Colorado says. I'm saying I have jurisdiction. So.
Understood, Your Honor. On the emergency petition, essentially to return, I guess, both children to Mr. Thomas, on Ms. Thomas's behalf, I would also say that, you know.
No, there's a, excuse me for interrupting, I apologize. Is there an order of protection still in full force and effect?
Yes, Your Honor, there is. There's also a pending contempt for those house break-ins. That is also in effect.
And under that original order of protection, what provision is made for I don't have the order of protection in this file, but
I can provide it. I believe Mr. Bellamy had said that Scarlett is listed under it, which is our oldest child. I did not see that, but I can provide it.
Well, and my question, of course, is what, if any, provision is made in that order of protection for the one child that's there that we know, Scarlett.
So I'm looking at the petition, and just looking at the petition, I do not see Scarlett listed on the petition, but it was the.
Thank you. This is the temporary order that I've been handed. And then you're saying that there's already been a hearing on that temporary order of protection and it was extended?
Yes, Your Honor.
And was that in circuit court or general sessions and then it was appealed?
It was appealed, and the appeal was not heard, and by agreed order, it was set off.
It was reserved for final hearing by
That's
previous
correct.
counsel. So it's my understanding the order of protection that was entered by the General Sessions Court is still in effect, and Mr. Thomas has no contact with either the petitioner nor the minor children covered under the order of protection.
Well, I'm looking at the order that was entered in this court after the hearing on February the 5th. In paragraph 2 of the findings of fact is the wife testified that she had been married to Mr. Michael Thomas' husband since 2024. The wife testified the parties have a 10-month-old daughter born of the marriage, Scarlett Thomas, and that she was also pregnant with the marriage's second child, which is due in early March. So according to Judge Wallace's finding, and that's the order that you're asking to be set aside, he made a finding based on her testimony that that was in fact the child of the marriage that's now in Colorado sought to be adopted. And it goes on to talk about these findings of fact nowhere in that order does it specifically order anything other than temporary spousal support. It doesn't put an order down regarding the temporary parenting plan or custody of the minor child.
That's my understanding as well, Your Honor. If I can say, though, we would object to Mr. Thomas having the children, and there's a lot of reasons to that, that maybe perhaps Ms. Thomas could add with testimony, but she's been the primary caretaker.
Well, Mr. Thomas filed for DNA testing. I'm not going to grant him custody of children that he has a question that whether or not,
Yes,
when
Your
I
Honor.
started practicing law, that was a factor that if a parent, a father requested DNA testing, that was a factor the court could consider in among all the other factors in determining whether or not he ought to have, what type of visitation or custody or whatever. So if he's questioning whether this is his child or not, then I'm not likely to say those children have to come back and live with him, especially in view of the fact that there are orders of protection in place.
Pending any questions, Your Honor, I have nothing else to add.
This is a mess. And I'm going to do one thing. I'm going to check with Judge Wallace. It may be better if I heard this case and through its, I don't really want to, but it may be better if I can do it. We checked on your availability on the 16th, is that correct?
Yes, Your Honor, I'm available.
But what about the 15th?
I can check.
What did we set on the 16th? Anything for me? Yeah, I can give you the 16th.
16th would work for me, Your Honor.
I'd like to just check with Judge Wallace. If he doesn't have an objection to me hearing the motion that you filed, then I would suggest we hear everything on the 16th. And if Ms. Thomas, I think we need to get this DNA testing done as soon as possible.
Understood.
So we're talking about June 16th to hear everything, all of these motions, and between now and then, I want the DNA testing performed on both Scarlett and the child that's in Colorado. That DNA testing will be performed by a sample taken by Mr. Thomas by LabCorp here in Hendersonville, sample for Mrs. Thomas and the minor child Scarlett in state where she resides by LabCorp, if there is one there, and by LabCorp in Colorado where this minor child is. It would be Mrs. Thomas's obligation to ensure that the child's sample is taken and that proof is obtained from Colorado of the validity of the identity of that child. In other words, I tell you this story that we had a well-known ne'er-do-well down in Humphreys County who is a member of a famous music family down there. And he was hired, or rather he was sued for child support. Back in that day, they set you up with the father and the mother, and the child all went to get the blood test done. So came back negative, and the mother just was irate, could not believe it. And anyway, they apparently took a picture of the father and the child and the mother. It wasn't the defendant. He had sent one of his buddies to go have sit in his stead, and of course it came back it wasn't. And later it was his child, so they had to redo it. What I want is to make sure that that child is identified in the state of Colorado sufficiently by whatever means, photography or whatever, that we can ensure that Mr. Thomas knows this child that is being tested in Colorado is in fact the same child that we're having questioned. And so I think we do that DNA testing, and I'd like to have that done within the next 10 days on all parties, and then we reset it for June 16th, and hopefully we'll have the results of that at that time. And I will check with Judge Wallace to see if he has any objection to me considering your motion to modify his order, and then we'll go from there. All the other motions I would think need to be heard on that same day. I realize it's an emergency type situation, and that's why I'm giving you the June date. I'm supposed to be in Humphreys County that month, so.
Appreciate it, Judge.
Anything else?
If I may, Judge, and this kind of gets into temporary support, I don't want to do that.
Well, he pays for his test, she pays for her test, and he's the one who's requesting the testing, so it's gonna, understand that I'll consider that at the next hearing, but he's gonna have to bear the cost of the test itself. She will pay for the test for herself and the two children. He will pay for his test and the performance of the actual DNA testing.
So we'll go with an itemized list of what the charges are for the test, and she's
Correct.
responsible for herself.
Right.
Understood, Your Honor.
Otherwise, the other option you have is tote that child back from Colorado, bring it here, and have all three of them, have all three, your client and the two children, tested at LabCorp in the state she lives in.
Understood, Your Honor. And I'm going to ask just one clarification and request to this court. If those are determined to be Mr. Thomas's children, can Ms. Thomas be reimbursed for her cost of the test?
If they are Mr. Thomas's children,
Yes, sir.
she can make application for reimbursement at that point in time.
Understood.
Normally, if someone contests that being their child and it turns out they are, then they requested the DNA, they have to pay for it in the end result. But as was pointed out, if he's incurring a great deal of expense to fight an adoption of a child he never consented to being adopted, then that may be a factor as well. So,
Understood.
all right. I'm of the opinion that we have it all heard on the 16th, and we will sort it all out to the best of my ability at that time. So we'll stand adjourned. Thank you.
Thank you, Judge.
You're going to draw the order.
I'll prepare an order, Judge. Thank you.
Yeah. That now it really looks like it too. There we go.
Sometimes I write out the word just to make it easier.
All right, whatever sentence shall not exceed a cap of 7 years in prison. So what we're looking at is no less than 2, no more than 7 years confinement in prison. You could be placed on deferred or unadjudicated probation. And you could be found guilty, sentenced from 2 to 7 years confinement in prison. That could be suspended, and you could be placed on regular probation, a different type of probation than deferred. 3 options. Do you understand?
Yes, sir.
What we will do is accept the plea today, then order a pre-sentence report, come back in a few weeks, and then everybody can add any additional information, and then the court will make its decision. Yes. So, if I follow this agreement, do you understand you have no right of appeal of your case? Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that voluntarily? Understand it? Discuss it with your attorney, or the contents are true and correct? You have to speak up.
Yes,
Yes.
yes.
State's Exhibit 1 tendered into evidence without objection.
No objection.
Admitted. The state you are mentally competent. Your guilty plea is freely and voluntarily made. You know what you've been charged with. You back this read to you, brother. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfying with the representation by Mr. Wilkerson. All of this is true at state, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Now, without objection.
No objection.
Step. We will order a pre-sentence report. We will return back on June 23rd, 2026. And then we will take up the matter of sentencing at that time. Anything else? We are recess on this. Thank you.
Thank you, John. Thank you.
I see when Mr. Kimler's client's still in the courtroom from the trial docket, is he excused?
Xavier Aguiar? No, I did. I was, sure. I got it. We'll see.
Yes, sir.
Okay. Okay, Xavier Aguilar, is he in the back? They're getting. I've got Xavier Aguilar Travis Jackson.
Yeah, we know he's right. Jackson's in jail now, I guess they were ready.
We're gonna get him after Joe.
Okay, yeah. Yeah, I'll sign it.
Then I've got two Joe Lewis.
Dismissals, those were,
Can I sign those?
you can, Judge. You can execute those.
Yeah, he was a great boxer.
He was. I couldn't fight my way out of a paper bag.
We've seen you do that, by the way, and we all find that comical. You in the paper bag.
I do like to entertain.
That paper bag and you, the paper bag is still undefeated.
Yes, sir.
I think Xavier, right up here.
Yeah. Okay, on
What else you need there?
1653.
Stuff you got?
Okay.
But I also help you.
25 CR 374 Joe Lewis, Joseph Lewis, that case is dismissed. 25 CR 494 State of Texas versus Joe Lewis. And that case is dismissed.
Wow.
Back to the money from. Say, and this, half of it, you're getting free for one time.
Oh, this is Xavier
Yes, sir, it is. Let's try to get on.
in.
No, ready straight to the right.
24 CR 1941 is called the State of Texas versus Xavier E.N. Aguiar, and that is you. Correct, Mr. Aguiar?
Yes, Mr. Judge.
Present with your attorney, Mr. Vasquez, I'm the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, Mr. Aguiar, this indictment alleges in paragraph 1. Are we just doing paragraph 1?
No, only paragraph 1.
All right. Paragraph 1 alleges that on or about July 29th, 2024, Jefferson County, Texas, you committed the third-degree felony of assault on a public servant, namely a Jefferson County Corrections officer. Do you understand what you're charged with here, sir? Oh, this is a third-degree felony. If convicted, you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand that?
Yes, sir.
The agreement's been reached in your case that you would be pleading guilty and sentenced to 5 years in prison. And you would be given credit for all time you have served in accordance with that case. Is that your understanding?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
I understand, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Correct, sir.
I'm going to show you what's marked as State's Exhibit 1 there. Did you sign that document?
Yes, sir.
Understand it?
Yes,
Discuss it with your attorney. Are the contents all true and correct?
They're all true and correct.
State's Exhibit 1 tendered into evidence. Without objection admitted. The state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, state, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
If nothing further, my everybody, I'm going to follow this agreement, Mr. Agnew. I'm going to find, sir, that you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony as indicted of assault on a public servant. I am following this agreement. You are hereby sentenced to confinement in the institutional divisions of the Texas Department of Criminal Justice Prison for a term of 5 years. You will be given credit for all time you have served. Do you understand what has happened today, sir?
Yes.
Anything else?
That's
Good luck. That is all. Thank you. No. Yes, sir. Travis Jackson.
She said, don't to see. That's perfect. UEF.
Your Honor, if I have ready to stop the docket, the Desmond Harper, he is in TDC right there. So he is not there.
Okay.
So I was letting you know that's.
Okay, Desmond Harper,
He's in TDC.
3 cases, 24 CR 84, 85, and 86, 24 CR 84, 85, and 86. The defendant is not here in Jefferson County. We must bring him forth.
Yes.
And we will have to reset Desmond Harper.
Your Honor.
We're gonna reset Desmond Harper's 3 cases for another time when we can get him back from prison. Thank you. Here. Mr. Jones. Pass. Got you. Safe as though, right? What are we doing on these?
Judge, I need to swear in.
We on both or one?
We're pleading on 2, dismissing 1. There's 3.
Really? I didn't see that.
Should be 3 cases, Josh.
Harper.
No, it's Travis Jackson.
Yes, I know.
Oh, okay, I thought you.
What I'm holding there.
Oh, I don't know if you're right. Yeah, you got to.
Patterson, Sanchez, Hassan, Bailey, Madison, Pomona, Elias. No problem. You sure?
Richie with his.
Much stronger. Yeah, right there.
This is funny.
No, that's good.
Uh-oh.
Travis Jackson.
Yeah.
You look good.
Can't find that.
Have 2 on my docket.
At 24, 354 and 355.
0093, that's message.
No, that's all I have. This is Travis Jackson, right?
Yes.
No, there's only 2 cases.
I have a 24 DCCR 0093.
I don't have, that's not on this docket. It's just 354 and 355 on this docket.
Same as right.
What's that other one all about? What is, see, I've got assault and taking.
Separated from the other ones, Judge. I got.
Yeah.
Place.
What are we gonna do with it? That third one?
That's one we're playing. That's not the main ones.
Turn the bottom off for there.
Hmm. We are back on the record. We have three cases, the state of Texas versus Travis Jackson. And first one we will deal with is 24 CR 354. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed?
Yes, Your Honor, please.
In summary, this indictment alleges that on or about January 18th, 2024 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you're charged with here?
Yes, sir.
A third-degree felony means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached where you would be pleading guilty and sentenced to 5 years in prison to run concurrently with 24 CR 73 and another case, 24 CR 355 will be dismissed.
Yes, sir.
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Correct.
How do you plead to this, guilty or not guilty?
I plead guilty.
Are you pleading guilty voluntarily and because you are guilty? That's a question. Yes. Are you guilty and because you are guilty? Correct.
Yes, sir.
And 93 is the other one.
Yes, sir.
Yes.
24 CR 93 was called. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, please, Your Honor.
In summary, this alleges in paragraph 1 that on or about November 29th, 2023 in Jefferson County, Texas, you committed a third-degree felony of obstruction or retaliation. It says that you intentionally or knowingly threaten to harm another by an unlawful act, namely assault and or murder in retaliation for or on account of the status of the victim, a person who had reported the occurrence of the crime. You understand what you're charged with?
Yes, sir.
This is a third degree felony. Again, if convicted of a third degree felony, stand by. You face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand that?
Yes, sir.
And an agreement here in this case shows that soon you would be pleading guilty, sentenced to 5 years in prison to run concurrently with the preceding case. And again, 24 CR 355 would be dismissed.
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this charge in 93, third degree felony of obstruction of retaliation? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you in each of these cases what's marked as State's Exhibit 1. Did you sign those documents voluntarily? Understand? Discuss them with your attorney. Are the contents all true and correct? State's Exhibit 1 tendered into evidence in each of these cases.
No objection.
Without objection, admit. The state you're mentally competent to enter your guilty pleas. They're freely and voluntarily made. You know what you've been charged with. The indictment's been read to you and you read them. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the right to appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
In each case, State's Exhibit 1, part of the record for all purposes without objection.
Okay.
Is it so? Pre-sentence reports are waived?
Yes, please.
On each of these cases, 24 CR 93, the third degree felony of obstruction or retaliation, and 24 CR 354, the second degree felony of assault on a peace officer. I'm going to follow these agreements and find that you, Travis, Nicholas Jackson, in each of these cases, you have pleaded guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea in each of these cases from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt of these offenses. I now find you guilty beyond a reasonable doubt of the offenses, a third-degree felony of obstruction or retaliation in 24 CR 93, and the second-degree felony of assault on a peace officer in 24 CR 354. And following these agreements, you are hereby sentenced in each of these cases to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. In each of these cases, these sentences shall run concurrently. Do you understand what has happened today, sir, in each of these cases?
Yes, sir.
Okay, I've got a dismissal in one of these, right?
Yes, sir, and I'm doing it right now.
Order.
You're leaving now?
This is gonna be the files. There's nothing put there.
Okay. There we go. Yeah, it's a good sign. Good one. That's another. No. Time I have witness on the one for the civil very. Rejecting.
Did you get it? Nothing yet. She sent a dismissal. One, of course, CR 355 is here not dismissed. I think that takes care of everything. It does. Oh, that is all right. Which case was it where there was an assault with the hand? Punching? Which case was that?
We did the manslaughter.
Yeah. You see the file real quick?
For Bird song?
Hey, you must be doing.
I want to make
I'm director going to trial in the moment.
that it shows that on Logan's song in this. Yeah, I did complete this. In this murder case that was reduced to a second-degree felony of manslaughter.
This is how far down the trial we are.
In that cause number 24 CR 341, the judgment now affirmatively showed that a deadly weapon.
Right?
Yes, Your Honor.
All right, Mr. View, anything from the state? Any additional evidence from the state?
Your Honor, no additional evidence, and we don't have any additional statements or input from the victim side.
So Benji, we recently did a home visit. How are things going?
Yes, Mr. Landis is doing well in the new group home that he's been placed at, and staff said they haven't had any issues, so he's been complying with his monitor conditions, and there hasn't been any issues on our part.
Sorry?
Yeah, I think Mr. Landis would like to address the court.
Okay, anything you want to tell me before he does?
There is nothing I would
All
like
right,
to
no
say.
additional evidence, right?
Correct.
All right, Mr. Landis, what do you want to tell me?
I want to appreciate, taking my, hearings and stuff. And I really deeply want to thank you for giving me a second chance. And I've kept my word. I have been going to groups, taking my medication on time, do our chores, sweeping up our rooms and hallways. And Jim Hardy already explained to you, most likely you have to wear this ankle bracelet. And I'm okay with that. And just let you know, I've worked on a lot of stuff since, the time I did in Summit and the other facility, 90 days. Now I'm working on 90 days at the Smith House, but it's pretty much going pretty good. So I'm wondering from you, I get up, take a shower, brush my teeth, go to these group sessions. Don't make any excuses. You can't go when you know you can. And I've grown, since the last time that we were in court. I've done exactly what you're asking me to do down the T. And I think I'm doing great now than I've ever been before. And I just wanted to, I appreciate, me getting back on my feet. And I already talked to Jim Hart. It'd probably be a while before I, can be taken off the ankle monitor. And the reasons why I went off the ankle monitor, I have a test I have to do, anxiety test. And I forgot the KEG where they stick, stuff on your head and put wires. But the bad news is about that, I won't be able to attend that because the ankle monitor was going to interfere with the testing. So I'm going to talk with the doctor when I go back and how they can make arrangements for me to do these things. It's very important. My health has gone almost sour. I've been having seizures lately. I had them in the past, and they're working me and helping me with getting this stuff done. And having seizures are not fun. And they were really good care of me, doing the right judgments. I have been out a couple of times on the walk at the place from at Smith House. No issues of coming back, no issues of leaving. And I just wanted to let you know that I respect you, and I'll continue to do so. So Jim Harden is making an effort for me to follow what he wants me to do in the courts. And I've come a long way. And like I said before in court, I don't want to get out here and be good. I want to get out here and be great. And prove people wrong like I've done before. And that's pretty much all I have today. Well done.
So I want to know a couple things, Mr. Landis. The first thing that I want to know is, what did it feel like to walk in the courtroom today for the first time, I think, ever without restraints on?
How'd I feel? It feels great. You got the burden off my back. And I'm still showing people that I can demonstrate wrong or bad, wonder and good, but nothing's going to bring back my brother. And I really believe that he, forgave me for what I did. It was not intentional, and I moved on for it. And I think my brother forgave me for what I did, and some of my family members pretty much gave up on me. They kept saying I was never going to get out, and they pretty much now they Now, since it happened, there's still no issues. Pretty much a lot of people interact with me, play board games, go for walks. And through all that, I still stayed on task with my medication and in group attendance.
Second question, Mr. Landis, how's your physical health? How's your physical health?
Pretty good, other than a couple of times I had a seizure. I went out to the hospital. The nurse and the doctor came to me saying, I have a knot in my chest and they don't know where it came from. It's about the size of a golf ball. And it's not really a threat so far, but I do want to review that in another 3 to 6 months. And I was supposed to go to a therapy issue, physical therapy today, but it got canceled. But other than that, it's pretty much doing what been asked to do, and that's to stay out of trouble and stay on task with what you're doing, and don't let anybody get in your way from following your dreams. And eventually I want to get out, Smith House, and settle down, find me a young lady and start me a family, live the American style. And I want to thank Jim Harden, the prosecutor, and Amy for their assistance as well. I feel a little comfortable now with the Smith House than I've ever done before. And that's pretty much all I got.
All right, court is going to continue the conditional release plan. I do find that you continue to be a mentally ill person subject to hospitalization, with the least restrictive treatment option being placement in the community. I don't have any changes to the conditional release plan at this time. It still contains the no contact order and the requirement that any facility that you are at, notify us immediately if you leave that facility without permission. I want to keep the monitor on for now, Mr. Landis. If there is a medical procedure that you need to undergo, just send us a letter from the doctor when it is, and we'll take the monitor off you for the purpose of that medical test. That shouldn't interfere with that at all. And we're probably going to review this administratively in 45 to 60 days to see if it makes sense to take the monitor off.
Okay, sir.
All right, anything else? All right, that's all.
So this is the last time that you'll see me in court.